amendment application comes into play. In terms of how to proceed, what I propose is that I go first and deal with both applications in turn. I'll try and finish before lunch, and that'll give my friend a bit of time, my learned friend a bit of time before lunch to open his position, and then the majority of the time after. And then I just ask for 15 minutes or so at the very end to reply, if that's satisfactory.
Are you okay with that, Mr. Dory?
Yes, of course, in Your Excellency's hands as to how you would be most assisted, but I've no issue with that.
Yeah, so can we say you have 2 hours, Mr. Cooper? May I address you, Mr. Cooper? Are you okay with that?
2 hours is more than satisfactory for me. Thank you, Your Excellency.
Yeah.
So, Your Excellency, I'm going to deal with matters in the following order. First, I'm going to take you through the sequence of events that have led us to the hearing today. And in doing so, I'm going to address this argument that's been put forward by the claimant that the defendant somehow consented to the amendments to the claimant's claim form. Second, I'm going to address the argument advanced by my learned friend that the claimant didn't need permission or consent to amend at all. Then I'm going to briefly deal with the law on strikeout, and finally I'll address the amendment application. So that's the order in which I'm proposing to take things. The first point, and I'm sure Your Excellency will have picked up much of the background from the skeleton arguments, is the sequence of events. And I do just want to take the court to the underlying documents because they are quite important. So, Your Excellency, this is a claim for rent and possession under a lease. My learned friend has spent quite a considerable amount of time in his skeleton argument commenting on the merits of the case. This is obviously not the time to get into a debate on the merits, which is a matter for trial. Suffice it to say that this is a far more complex matter than my learned friend seeks to paint it, as illustrated by the decision of His Excellency Justice Nasser to transfer this claim from the small claims tribunal into the court of first instance so that it can be subject to the proper procedures, document production, witness statements, etc. We don't accept for one moment that we do owe money to the claimant or that they're entitled to possession. But as I say, I'm not proposing to deal with the merits at any length because that's not the function of today's hearing. So,
if it would, but I will understand from your opponent that it might, because the background and the merit might help him.
well, my learned friend,
the court relief from, if there is a sanction, then relief from sanction, because I know his primary case, he didn't need permission, or he didn't need, because he got the permission automatically. But I'm sure the merit might help him in putting his case. So let's give him the benefit of that doubt, I said, but 6 excuses.
Well, Your Excellency, I think perhaps in that case, I'll let my learned friend develop his position on the merits, and then I can deal with it very briefly in reply. Principally, both of these applications are concerned with matters of procedure, and so that'll be the focus of my submissions.
To a very far extent, I agree with you, but I do think, I mean, to take things in, I mean, for a judge to be aware of the circumstances and then and the factors and the principles, and then what a claim we're pleaded, and whether if there is any new things, a new claim introduced, or a new cause of action introduced, I think from practice is you would need to look at some of the background and some of the merit grounds as well.
Yes, well, in that case, Your Excellency, let me take you through the statements of case, and I'll show you how they've developed and how the claim is structured and the additions that have been introduced most recently. So
I leave it up to you as long as you stick to the time frame. So 1 o'clock is a lunchtime.
Yes, Your Excellency, I'll take that on board and I'll do that now. So, Your Excellency, if you could start by just going to page 1 of the hearing bundle.
Yes, the claim form.
Yes, this is the original claim form dated the 4th of October 2022.
Yeah.
And it was issued in the court of first instance. And Your Excellency will see there are a number of oddities about this claim form. The first is that it wasn't actually issued by what is now the claimant, which we refer to as FMED. It was issued by someone called Sumit Ahuja. And again, It was issued against not the current defendant, Orange Chameleon, but rather the director of the defendant, Mr. Elamin. So we say that was obviously wrong.
Yeah, he named himself a claimant as well, not just representative, isn't it?
Yeah, so exactly, he put himself down as the claimant himself instead of just someone acting on behalf of the claimant. So that was very peculiar. If you then go forward in the bundle to page 60, so Your Excellency will tell me if I'm going too fast, but this is the what was called the particulars of claim. But in fact, as Your Excellency will see, it's not a particulars of claim at all. So
it's
again,
shorter than the claim form.
Yeah, it's very confusing, but it's common ground that neither of these documents were ever validly served. And what that meant is that the claimant was able to amend the claim form without permission at that stage, which is what it did on the 14th of December 2022. If you just go forward to page 62.
Just 62? Okay.
Yeah, so this was the second iteration of the claim form, dated the 14th of December 2022, and you'll see that the claimant has been corrected, the defendant has been corrected. And Your Honour, you asked about the nature of the claim. I just want to take you over the page to page 63 to draw your attention to the details of the claim.
Right.
So, Your Excellency, you can either read this in full and take your time to do it, but in
The
summary,
red square? The red square?
I'm looking at it printed, so I'm not sure. Yes, it will be the red square.
Yeah.
Particulars of claim included details. I'll give the court a bit of time just to read that.
So they're claiming 911,000. Okay, 911. Requiring tenant to vacate the premises by 5th of October. Okay. Liquidated damage for 640,000.
Yes. So Your Excellency will see that the claim, as originally brought, was entirely premised on the notion that the claimant had validly terminated the lease. They say they had validly terminated the lease, a point which we deny, and then as a result of that, they were entitled to possession, rent, liquidated damages, etc. So I'm just going to ask Your Excellency to bear that in mind when we move on to look at the later iteration of the claim form.
Yes.
Just a very quick point. My learned friend says in his skeleton argument that this claim form was served on the 15th of December, so the following day. My instructions are that that is actually incorrect, but I don't think it's actually relevant to the issue. But insofar as it does become relevant, our position is that this was never served. What then happened, Your Excellency, was that these proceedings were transferred by the Chief Justice into the Small Claims Tribunal. I don't think it's necessary to take you to the order, that's common ground. And what that meant was that the claimant had to transpose the contents of this claim form, which we've just been looking at, the 14th of December claim form, onto a Small Claims Tribunal claim form, which is what it then did. So if we go to paragraph 65, sorry, page 65, Your Honor, Your Excellency. So this is the Small Claims Tribunal claim form.
Yes.
And what I want to draw the court's attention to is the fact that the details of the claim are exactly the same as the 14th of December details. So it's not necessary for Your Excellency to read it all again, but if you go over the page to 66.
By photographic memory, yeah, it looks the same.
Well, yeah, Your Excellency, I'm very envious of your photographic memory. That would make my job quite easier.
Sort of,
Yeah, so this is exactly the same. And so once again, the claim is premised on the notion that the lease has been terminated and everything flows from that. So this is the claim that came before His Excellency Justice Nasser al-Nasser on the 30th of May. And having considered the arguments of both sides, he concluded that this claim was too complicated for the Small Claims Tribunal. And so he transferred it back to the Court of First Instance. And I'll just take you to that. It's page 90 in the bundle.
right.
So paragraph 1, the claim should be transferred to the Court of First Instance. Paragraph 2, the parties shall, over the page, paragraph 2, the parties shall serve a timetable. And then over the page again, there's a schedule of reasons, which essentially says that this is a case involving allegations of breach of fiduciary duty. It's no longer appropriate for the Small Claims Court, and there may be a need for oral evidence. So it's essentially a classic case for the Court of First Instance. So, Your Excellency, in accordance with the judge's direction, we wrote the claimant. And I'm going to take you to that letter because it's absolutely key. It's at page 143 of the bundle.
Is it 9th of September or what was it?
It's the 9th of June.
9th June, sure. Yeah. What's the page number again? 120?
It's 143.
Yep.
So, Your Excellency, the key paragraph, or the paragraph which is in dispute, is paragraph 1. We say the claimant should file and serve an amended claim form in P701 format, so in the CFI claim form format, and particular claim by the 12th of July 2023. Now, what my learned friend says is that by using the words amended claim form, what we were doing was giving the claimant our consent to amend its claim in whatever manner it wished. So it could change the quantum, it could change the nature of the claim, it could change the parties if necessary. That's their case. That is obviously not what we were saying. What we were saying is
He was about to say changing the court.
Yeah, so what we were saying was that the claimant should, as it did when it moved from the CFI to the Small Claims Tribunal in the first case, it should transfer the contents of its claim form onto an amended claim form in P701 format. So in the appropriate format for the Court of First Instance. Why didn't we just say a claim form in P701 format? Well, because as you've seen, the claimant had already filed an amended claim form. And so any newly filed P701 claim form, any newly filed Court of First Instance claim form would also have to be an amended claim form. But the logic of my learned friend's position is that despite the fact that the claimant had given absolutely no indication of any intention to amend, the defendant gave its consent to the claimant amending its case in whatever way it wished, just in case the claimant might want to amend, and without even requiring the claimant to provide the amendments in advance so that we could look at them and check them. That is just completely implausible, Your Excellency. No litigant would ever offer their consent in those circumstances. And this is why we say we don't actually accept that the claimant ever thought that that's what we were doing. And this is reinforced by the claimant's response at the time.
But we said, I mean, whatever meant by that letter must be interpreted while taking into account only changing the format from SCT forms to CFI forms.
Yes, well, I mean, that's what we say. We were.
That's what that should have been put in square and should not go beyond it.
Sorry, Your Excellency. I think we're saying the same thing, which is that this should have been read as just, please change the claim form from small claims tribunal claim form to court of first instance claim form.
And they have taken it in a different way. They have taken it as an open-ended, a consent to change the format, change the claim form, change the cause of action, and bringing new elements to the
they say exactly, Your Excellency. They say, oh, well, what this means is we could change our case in whatever way we want it, and you consented to that. Well, I mean, obviously, that's not what we were doing. They hadn't even suggested that they wanted to amend. We hadn't seen any draft amendment particulars, any draft amended claim form. Obviously, we're not consenting to something we haven't even seen and don't even know they want to do.
Oh, I see. Yeah. I see what you mean. Yeah.
I mean, really, this is, I'm afraid.
You're talking about a logical consent with someone would send you something and ask you, would you consent? This is the rules in an amending statement of case. And then, yes. Mr. Defendant, would you please look at this? We are about to, or they either ask you, we are intending to amend, or put something before you.
Yeah.
And then you look at it and then you respond.
Exactly. But we had none of that.
This had never happened. That's what you say.
Yeah, this had never happened. We had no idea that they even wanted to amend. So the notion that we consented in advance just in case they might want to amend is just ludicrous. And so, Your Excellency, I'm afraid this is why we say this is just a cynical sort of post facto justification for the claimant's stance. And Your Excellency, this is reinforced when we go and look at the reply to this letter. So the reply was on the same date. It's page 144, so just the next page.
Yes.
So they say, we expect to be in a position to file the amended claim form particulars of claim by 16th of June. That's fine. It's just mirroring our language. But then, tellingly, when they come to produce their own draft directions, paragraph 1, they say the claimant is to file and serve the claim form and particulars of claim. So they've actually dropped the word amended. Now, if they thought that we were giving them consent to amend their claim form, that would have been a very strange thing to do. If you say that the other side is consenting to your amendment and you want directions to codify that, then you want those directions to be as clear as possible that you have consent and permission to amend. In fact, what they've done is remove any reference to amendments.
Yeah, but can one look at it like this is number one? The claimant is to file and serve the claim form. So like the claim form is the claim form we know, we knew about. So it's not about amendments, not about a new thing, isn't it? Well, maybe the wording can be sent. This is what they should have meant.
Well, Your Excellency, I agree. The claim form implies the existing claim form, not some amended claim form.
Yeah, so the number one serve your purpose in this case. Let's go to number 2.
Well, the rest of the directions aren't particularly relevant to this issue because they're about timings for the remainder of the statements of case. But Your Excellency, just to take this on forward.
Are you saying from this letter you do not see any clear intention about a new amendment or about a new ground or about a new cause of action that's to come to the bleeding, isn't it?
Exactly. Yes,
that's what you're saying.
Yeah, there's no indication here of an amendment. In fact, they have removed the word amendment or amended. And so, Your Excellency, if you go over
Yeah,
the
word only appeared amended in the second paragraph, first line in the middle. We
exactly,
expect to be in a position to file and serve an amended claim form.
yeah. But then
Actually, even they're saying the amended, not an amended one. I mean, you know what I mean? Even there is there. I mean.
yes, I mean, it could, as you say, it could have just been a reference to the previous amended claim form. It's completely unclear. There's no indication here that they're going to introduce an entirely new alternative claim.
Yeah, we'll see. Yes,
So,
go on.
Your Excellency, going over the page 145, we
yeah.
Paragraph 1. So we agreed to paragraph 1 of their proposal, so that they would the date for them to file and serve their claim form. And there's just one other point while we're here. My learned friend says in his skeleton argument that the reason the defendant asked for 28 days to file and serve its defense was because it knew that the claimant intended to amend. Well, as I've said, we had no idea that they had any intention to amend. And in fact,
that's one. But you never submitted any defense before this stage, isn't it? So it's going to be your first defense, is that right?
It would be our first defense, yes.
I see. Okay, go
on. But so, I mean, he's saying that in this letter, my learned friend says that in this letter, we sort of implicitly recognized that we knew that they were going to amend. But that just isn't what we say. So if you look at paragraph 2.4, if Your Excellency just reads paragraph 2.4.
Yeah, it's open for me.
Yeah. So what we're saying here is that the claimant has never produced a full particulars of claim before. So this is going to be the first time that it does so. And that's why we need 28 days for our defense. As you say, we've never had to produce a defense to a particular claim before. So it's not because we know that they're going to amend. It's just because we've never produced a full defense to a particular claim before. That's why we needed 28 days. So, Your Excellency, this correspondence was subsequently embodied in a consent order. If I could take you to page 92.
Give me a second, please.
Pardon me.
Yes, Mr. Scuba.
Yes, Your Excellency. So this was embodied in a consent order, which is at page 92 of the bundle.
Yes.
And when Your Excellency is there, you'll see paragraph 1. Again, the claimant is to file and serve the claim form and particulars of claim by a given date. So again, there's none of the usual wording when a party is permitted to amend along the lines of the claimant has permission to amend its claim form in the form attached to either the order or its application, or anything about how the claimant will pay the defendant's costs of an occasion by the amendments. There's none of the language that you would expect to see if amendments were to be made. So Your Excellency won't be surprised to hear that at this point, we had no expectation that any amendments would be made to the claim form. We expected the claim form to be just a transposed version of the small claims claim form into the Court of First Instance format. So now let's go look at what we actually received, which is at page 77.
Yes.
And actually, Your Excellency, if you just go to page 78, we have the brief details of claim, and Your Excellency will see will see from that from what you've seen before that the start of these brief details of claim are identical to the previous version, and it stays identical all the way up to page 79. But then at the end of 79, we get this addition. 79.
The defendant has not acknowledged from that.
Yeah, just after that, we get the alternative. Even if the notice of termination is found not to have been valid, rent would still be due. So we have this entirely new alternative claim. And this wasn't drawn to our attention, by the way. We had to spot this. And then again, if you go over the page and look at the remedies section, there's again a paragraph on page 80 which starts in the alternative, and then a whole ream of alternative relief.
What is the remedies? Okay, yeah, I see. In the alternative, the claimant seeks an order from the court. Yes.
Yeah, and etc. etc. So what we have here is an entirely new alternative claim.
The new alternatives and new alternative remedies are never mentioned in the previous one, isn't it? But I can see some of them we've been already addressed, like, you know.
Well, some of the remedies are overlapping, but they're based on an entirely new sort of way of framing the case. So as I showed you previously, the case was entirely framed on termination having already taken place. And now they're running this entirely new case that in fact termination, if termination hasn't taken place.
Okay, let me ask you this, Mr. Cooper. I mean, before, I asked the claimant about it. Despite the fact that we do see an alternative case bleeded and alternative remedies, these two things were not addressed completely during the claim form, or not even touched upon previously in the old claim form. We just looked at the first one.
No, this whole notion that of an alternative claim was literally never mentioned at the last hearing, at any point before this claim form was served. The first time we had any indication that they were bringing this alternative claim was when we received the claim form. And then again, it wasn't drawn to our attention. We had to spot it. And Your Excellency, this is carried, that alternative claim is carried on into the particulars of claim, as you would expect. So if you go to page 73 of the bundle. 73. Your Excellency, actually, at one point while we're here, there's actually they've also added an additional remedy to their old claim. So paragraph 18A, an order declaring that the lease was terminated, that's actually additional as well. I mean, that's not the most egregious aspect. The most egregious aspect is the alternative claim for rent arrears. But I mean, changes have been made in both to the main claim and to the alternative claim. But if you look at, so at the bottom of 73, there's an alternative claim for rent arrears. And then over the page, we get a full pleading out of that alternative claim, which is entirely outside the scope of the original claim form. So
Yes, I can see this is, first of all, it's a bit lengthy part of a claim compared to the previous one, and detailed one, and
so
yeah.
yes, Your Excellency, unsurprisingly, indeed faced with this, we have issued an application to strike out these additions. And I'll make that application in a moment. But essentially, the claimant has three responses to this. First, it says, well, oh, you consented to these amendments. Well, I've already dealt with that. We absolutely did not consent to these amendments. We had no idea they were going to be made. Second, and Your Excellency will notice that there's a slight contradiction in this. They say that they never actually needed our consent to amend anyway, and they didn't even need permission. And I'm going to come on to that argument next. And then thirdly, the claimant has applied for retrospective permission to amend. So it's basically trying to cure its breach, and I will deal with that
Which
last.
is the current application.
Yes, so that's the application which my learned friend has brought in, which is also before us today. So I'm going to start with the strikeout application, this notion that the claimant didn't actually need either permission or consent to amend. Your Excellency, do you have access to the DIFC rules? And if so, could you go to part 18?
Yes, I do. I have it in the booklet better than opening 3 different screens.
Okay. Yeah, so if you look at part 18 and just read part 8, I'm sure you're very familiar with this, but 18.1 and 18.2.
Party may amend his statement of case anytime before has been served on any party to condition written consent of the other parties, permission of the court.
Yes. So the rules make a very basic distinction. Before you serve your statement of case, you can amend it without permission or consent. After it's been served, you need either permission or consent. And the reason for that is obvious. Before the other side has seen the statement of case, it doesn't matter to them whether it's amended. They've never seen it. So as I've shown you, the claimant has already served a claim form, the small claims claim form. All that's happened is that that claim is being transferred into the court of first instance. So it's the same claim form, just going to be put onto a different bit of paper into a different format. So the claimant needed either the written consent of all parties, i.e. our written consent, which we didn't provide, or permission of the court. Now, my learned friend has come up with a sort of ingenious but completely flawed argument to get around with this. And that's based on the wording of Rule 53.41. So if I could ask the court to turn up RDC 53.
You refer to 53.4.1 or 41?
41, apologies, Your Excellency.
41, sorry. Right, yeah.
And so what's this is the rule which allows a judge to transfer, or as the heading shows, reallocate proceedings from the small claims tribunal to the court of first instance. And it says, where appropriate, the small claims tribunal judge may issue a reasoned order that the small claim be transferred to the court of first instance to be progressed as a fresh claim under the procedures followed by the CFI. And when doing so, the judge will have regard to the following matters. We'll look at some of those in a second. So, Your Excellency, I'm sure doesn't need me to tell you this, but the words progressed as a fresh claim under the procedures followed by the CFI do not mean that the party can throw out their existing claim and start a completely new claim. I mean, my learned friend goes so far as to say that they could start a new claim with new causes of action, new defendants, completely different quantum. I mean, there's, according to my learned friend, there is no limit on the amount by which he could change his claim as a result when being transferred from the small claims court to the court of first instance. That is not what the words "to be progressed as a fresh claim under the procedures followed by the CFI" mean. What they mean is that you need to go back to the start of those procedures, i.e. particulars of claim, document production, defence, reply, document production, etc. And the reason for that is that in the Small Claims Tribunal, various bits of the Court of First Instance procedure are missed. So, for example, there isn't typically a process of document production, document requests. There isn't typically a particulars of claim. The number of case management steps are far more abbreviated. And so what the court is saying is that where it's appropriate for a case to be tried in the Court of First Instance, you go back and follow the Court of First Instance procedure to make sure that none of those procedural steps have been missed. You don't, for example, say, as in this case, the case was ready for its final hearing. You don't just go into the Court of First Instance and go straight to trial. You have to go back and start again with particulars of claim and move on from there.
I mean, I don't know if I remember what Mr. Doherty was saying, but is it something can be taken because after the transfer between SCT to CFI level, so Mr. Doherty would believe that the submission, sorry, the case statement of case, I mean, claim form in particular, would have to be served again on you. And from that basis, so he would treat it like it's a new, fresh claim to be served on you, so you will not be taken by surprise. So your consent is not necessary.
Well, our consent...
Because they're going to be service anyway. New service.
Right. Your Excellency, I mean, I appreciate that is my learned friend's argument. That is completely and obviously wrong for reasons I'm about to describe. Yes, you can produce a part, and I would say you should produce a Part 7 claim form so that you're using the right forms for the Court of First Instance. But that claim form has to be an identical form, in substance, identical to the Small Claims Tribunal claim form. Otherwise, you are completely subverting both the transfer regime and also Part 18. And I'm just going to take Your Excellency through why I say that. The implication, as I say, of my learned friend's position is that he can completely change his case, even down to changing the parties. But if that's right, then Rule 53.41 becomes impossible to implement. So if you go back to Rule 53.41, Your Excellency, look at the factors which the judge needs to have regard to. So it needs to have regard to the financial value of the claim or the subject of the claim. It needs to have regard to the nature of the dispute, the nature of the remedies sought, the likely complexity of the facts, etc., etc. So the judge is being asked to look at the claim as it is in the Small Claims Court and say, would this be more suitable for the Court of First Instance? Now, if, as my learned friend says, the case could be completely changed between the Small Claims Court and the Court of First Instance, this task would be impossible, because the judge would be asking himself, what is the financial value of the claim? Well, I don't know, because it might completely change by the time this case gets to this Court of First Instance. What's the nature of the dispute? I don't know. It could completely change by the time this gets to the Court of First Instance. What's the nature of the remedy sought? I don't know. It could completely change. I mean, even the parties, the defendants, could completely change on my learned friend's case. So the task which the court has to undertake in determining whether to transfer the case would be made completely impossible if what my learned friend says is correct. My learned friend seeks to rely on the fact that paragraph 4, for example, uses the word the likely complexity of facts, and there's also a reference to the likely parties. And he says, well, look, this must mean that the court envisages that the case might change between the Court of First, between the Small Claims Tribunal and the Court of First Instance. No, that isn't what those words mean. The reason the court is referring to the likely complexity of the facts is because at the point which transfer is usually contemplated, there may not have been witness evidence, and certainly there won't have been submissions on the law. Ordinarily, there won't have been submissions on the law. So the court is going to have to speculate to an extent on how complex these matters are going to be. That's not to say that the claimant can completely change his case. Similarly, the rules recognise that parties can be added at a later date in compliance with Part 20 of the rules. That's why it refers to likely parties. But that doesn't mean that between the Small Claims Tribunal and the Court of First Instance, the claimant can just abandon his claims against the current defendants and bring claims against entirely new defendants, which is the implication of my learned friend's case.
Then why would, I mean, when someone would ask this from a rational point of view, why then the process would require a service? If it's the matter only changing the format, then why do we have to serve the other party?
So
for them to make sure that we did not add anything, because the paper would be before them anyway.
Oh, so okay. So if the party had, if the claimant had decided just to use its existing Small Claims Tribunal claim form, then you wouldn't need to reserve that because that's already been served. But obviously, if they're going to put the claim in a Part 7 claim form format, which they probably should do, then that will need to be served because that particular document is not would otherwise not be before the other side. It's just the reason you serve is just to make sure that the other side has the document. It's no more complicated than that. Does that answer Your Excellency's question?
Yeah, I see your point. Yes.
So, Your Excellency, just standing back, the reason that you transfer a case from the Small Claims Tribunal to the Court of First Instance is to ensure that it follows the most appropriate procedure for that claim and to ensure that that claim is heard before the most appropriate tribunal. So there is no logical reason why that should result in a party being able to change its case. I mean, the two just don't follow. That's not why transfer exists. Transfer exists.
Maybe someone, I mean, it's me. I'm not doing devil advocacy, but I'm just thinking loud.
Yes.
Usually the process before the SCT, where party usually are not represented, or the representation is beyond the court boundaries, you know what I mean, or away from the court.
Yes.
Transferring the case to CFI would require another legal work, legal backup. Party, I mean, laymen would maybe need definitely to rely on lawyers to put their case, to plead their case in.
Yes, absolutely. So, I mean, as I pointed out before.
So yeah, as I said, it's fairly. We can see a change of circumstances between serving or, I mean, litigating under the SCT level and the CFI level. Like, it's different regime, different professionalism needed, different accuracies. I mean, parties to the CFI got pay extra fees, maybe they do another preparation, more procedures, more case management, witness exchange that doesn't happen during the SCT level.
So, Your Excellency, I agree. I can completely understand why a party who now has lawyers, I mean, in this case, they've had lawyers from the outset, but or close to the outset, but I can totally understand why a party who goes to the CFI, instructs lawyers, might want to change their case. They might want to elaborate on their case. I mean, there's two ways they could do that. One, they're not going to have filed a particular claim before, so they can just elaborate on, they can elaborate their case in their particulars of claim, provided that that's within the scope of the existing claim form. They obviously can't exceed the scope of the existing claim form. Or if the claim form as currently drafted is not satisfactory, then they might apply to amend. But the question is not, is there a reason to amend? The question is, are they allowed to amend without permission or consent? The answer to that question is obviously no. I mean, yes, by all means, the parties can apply to amend at any point. It may be that once you've been transferred to the Court of First Instance, that's an opportunity to seek consent or permission. but that doesn't mean you can do it without consent or permission.
What I see. I mean, maybe Mr. Doherty would argue that, I mean, one of the consequences of the transfer from the SCT to the CFI, that parties will abandon the procedures and the submission before the SCT, and then you're starting afresh there.
Well, maybe they do.
And then, yeah, and then starting afresh, you would have your own claim form to be served on the other party.
Yes, well, Your Excellency, I mean, parties may well want to change the way that to abandon a previous claim. But if they do that, then they'd be discontinuing, and they'd be faced with the cost consequences of discontinuance. I mean, it can't possibly be right that a party runs its case in the small claims tribunal, and then just because it's transferred to the court of first instance, they're allowed to abandon that claim without giving the other side even opportunity to ask for their costs. I mean, that would be absurd.
Let me put it before you. I mean, for three of us maybe. According to the current rules, whether at the CT Part 53 or CFI level Part 7 or even Part 8, wherever, or even go to the service, is there a mandatory by any rules or brass direction if your case transfer from the SCT, you are banned from submitting a fresh claim form or a fresh particular of a claim?
No,
I understand what you're arguing is your interpretation to the rules. I mean, the rationale of the rules. Maybe is that right? But do we have a clear restrictions that the bleeding of the SCT should be the bleeding before CFI, and if you want to change, you need to have a permission of parties or court. And then I would reverse this question to Mr. Doherty other than, what's give you the permission to sell a completely fresh submission, either claim form or even part of a claim? And then he might say if there is no restriction, then I would take the benefit of no restrictions. So but that is my question to you. You know how I'm putting your case.
Your Excellency, I mean, I obviously welcome your testing of my case. Your Excellency does a very good job of playing devil's advocate. But so there's nothing which says specifically when you transfer from the small claims tribunal to the court of first instance, you're not allowed to change your claim form. But that's because there doesn't need to be. We already have Part 18, and Part 18 says after a statement of case has been served, in this case the claim form, a party may only amend with the written consent of the parties or the permission of the court. So,
yeah, but you're not taking my hypothetical question with the consequences of the transfer from the SCT to the CFI, whether parties should have abandoned the process, the procedures, or the submission was that done before the SCT, as I said, because of the nature of the work business to be done before the SCT. I mean, we need to take everything along, isn't it?
Your Excellency, you're absolutely right. I mean, it may be that this is, I mean, I would say that the reason there is no express rule preventing this, saying when you transfer from one court to the other, you can't change your claim in whatever way you like, is because it is so obvious that it goes without saying. And the reason it's so obvious is because we already have Part 18 setting out when you can amend and when you can't amend. And as I say, the logic of it just doesn't make any sense. In order to decide whether or not a transfer is appropriate, you have to proceed on the assumption that the claim that is before you now will be the claim that appears in the court of first instance. And if that claim could be radically altered, even to the point of changing the parties, that would make the task of the court completely impossible. And it would also, there's also just no logical reason for it. As I say, I mean, I accept Your Excellency's position that parties may want to amend, but there's no logical reason why they can't, why they shouldn't apply for permission in the ordinary way. Or put it another way, there's no logical reason why they should be able to amend without permission.
So you're saying Mr. Doherty have no right to believe that he should start afresh at the CFI level? he have to be bound by a submission before a different court that abandoned its procedures and even ask for transfer of the case for complexities or for or other reasons.
Well, it's not a question. Mr. Doherty actually did represent the claimant in the Small Claims Tribunal, but it's not a question of Mr. Doherty being bound. It's a question of the claimant being bound. The claimant is advanced.
But I'm referring to him as a claimant anyway.
Yeah, I mean, the claimant. It's as simple as this, Your Excellency. No party can amend unless the statement of case has not been served. No party can amend without permission or consent. That is the rule. That's been the rule for yonks. The fact that a person is transferring from the Small Claims Tribunal to the Court of First Instance does not mean that Part 18 of the rules is thrown out. It doesn't mean that you can start the claim that you can bring an entirely different claim against entirely different parties and just abandon what you've done previously.
Well, but Mr. Doherty never served you a Part 7 claim form, Part 7 particular for claim.
Yes, Your Excellency, that's right.
But so that's why maybe that's a ground where he can start afresh.
Well, I mean, it's a very unpromising ground, Your Excellency, because he did serve. I mean, what Mr. Doherty would have to say in those circumstances is that even though he served an SCT claim form, just because he's serving a different piece of paper, just because he's changing the format of that document, that makes it a different statement of case. I mean, that is obviously not right. It's the same statement of case, it's just expressed in a different format because you've moved from the Small Claims Tribunal to the Court of First Instance.
So you're saying there is even no ambiguity around the matter. So if he have served anyway by any mean under any process, then he have to have a permission to amend.
Absolutely. I mean, I don't think there is any ambiguity. I think it is completely obvious that my submissions are correct. I don't think that the alternative has any merit whatsoever.
You're not saying even there is a loophole in this in the process, even.
I mean,
to allow this, yeah.
If there is a loophole, then I would say using that loophole is an abusive process, and I'll come on to make submissions on that.
Mm.
But I mean, my learned friend is doing the best that he can for his client, which has put itself in a very sticky situation, and he's running the arguments, the best arguments that he thinks are available to him. I make no criticism of my learned friend for that, but that doesn't make the arguments good. The arguments are thoroughly bad, and obviously so.
Go on, continue, please.
So, Your Excellency, my learned friend places some reliance on...
I hope I'm not slowing you down, I mean, a lot, because are you...
Your Excellency, I think it's very important that...
because I don't think I can be generous with you toward the end. I mean, by lunchtime, I will stop you.
Yeah, Your Excellency, I mean, I welcome your questions. I think it's really important that we flesh this out in full, because, I mean, it's such an important point. And if the wrong decision is made, it may set such a bad precedent. So, Your Excellency, my learned friend also places some reliance on CPR 53.41. Sorry, 42, pardon me. So, if you could turn up 53.42. So, what this says is, a claimant in an SCT claim that is transferred to the CFI in accordance with 53.41 is at liberty to pursue its claim by filing Part 7 claim form. So this is the point we've already discussed. A claimant can, instead of just using its SCT claim form, transfer that information onto a CFI claim form. And the reason that this rule has just been recently introduced. And the reason that it's been introduced, it seems to me, is because of a recent decision, which actually my learned friend cites. So if I may, I'd like to take you to that decision.
Yes, please.
It's in the Claimant's Authorities bundle. And it's actually the first authority, so page 1. So, Your Excellency, are you with me?
Yeah, I'm trying to locate the authority again. It's section D. You're referring to section D? Sorry, section C.
I'm looking at everything in the hard copy. One moment. It is So it's going to be section E, tab 2.
A2, page 1, isn't it?
Yeah, page 1. So you're actually, this is the case of Kayat and Al-Qahira Capital Dubai. It's a very short report. It's basically just the order. Essentially what happened is the claimant issued in the Small Claims Tribunal. The claim was then transferred to the Court of First Instance. And then the claimant issued a new claim form. And what the judge found at paragraph 1 was that by issuing a new claim form, the claimant had started a new claim. So they say, given that that case number is filed as a fresh claim, it's not administratively a transfer or reallocation, and so the claim form stands. So in other words, the claimant had accidentally, by issuing a Part 7 claim form, started a new claim instead of just transferring it, instead of just having his claim transferred, which is obviously not what was intended. And so it seems to me that the reason why Part 53 was amended was to make it clear that if you're in this situation, so if you move to the Court of First Instance and you want to transfer your claim into Part 7 format, by filing that claim form, you're not starting a new claim. You don't have to pay a new issue fee, etc., etc.
But in this case, it's transfer from CFI to SCTs, the other way around, isn't it? Or a CT to CFI. Okay.
Yeah. So yeah, what this case shows is the issue with the old rules, which didn't make explicit that if you take the contents of your Small Claims Tribunal claim, move it onto a Part 7 claim form, as you probably should do, given you're proceeding under Part 7, you're not accidentally starting a new claim. You're effecting a transfer. So that it seems to me is the reason for 53.42. It's absolutely not saying what my learned friend seems to think, which is that you can scrap your existing claim, start a new claim, complete the new course of action, complete the new defendants. I mean, according to my learned friend, the effective transfer is that the claim you bring in the Court of First Instance can have literally no relationship to the previous claim in the Small Claims Tribunal.
Yeah.
So, and Your Excellency, there's just one final point which my learned friend makes in his skirts and arguments. Tell me if I'm going too fast.
No, you're good.
So my learned friend, I think, makes a point at one point that under the new rules, transfer is no longer a reallocation or something. I'll let my learned friend elaborate on this, but I just want to, I'm not sure I understood his argument, but I just want to point out that even under the existing rules, if you look above RDC 53.41, it's still a reallocation. This rule is not entitled, the judge may put an end to the small claim and the claimant may start an entirely new claim. It's still a reallocation or a transfer.
Where the word reallocation appears to be?
It's just above just above 53.41. The title is reallocation.
Still. Yeah, the title, yes, the bold title, yeah.
Yeah, exactly. So that hasn't changed. It's from the old rules. It's still a reallocation, as we expect. And Your Excellency, actually, just one more point. At one point in my learned friend submissions, he seems to say, in fact, let's take you to it. Your Excellency, do you have the claimant's skeleton argument?
Yes, I do have.
So if you could go to paragraph 55.1.
Just give me a second. Paragraph number?
55.1.
Yes, and the relevant law. Yes.
It should be under
Oh
submission.
no, submission, sorry.
Yes.
Yes.
So this paragraph requires some close reading. He says, the amendments to seed statements of case were made prior to it having been served, because previously there had been no particulars of claim at all. And so what he says as a result of that is that they could amend without permission under 18.1. So this is a sort of red herring. The particulars is completely right that no particulars of claim have been served before. We're not really interested in the particulars of claim when it comes to the unlawful amendments. What we're interested in is the claim form. And he doesn't say that the claim form could be amended under 18.1. But of course, as your Excellency will know, your particulars of claim can't include claims that aren't included in the claim form. So the fact that they could produce a new particulars of claim, which we've always accepted they could do, doesn't mean that that particulars of claim could include claims that weren't in their claim form.
And they're not saying they're not serving a new claim form here.
No, then so they don't seem to be relying on 18.1 when it comes to the claim form. It's only when it comes to the particulars of claim. But it's the claim form which determines the scope of, or, well, the widest extent of the claim that they're allowed to bring. I can cite authority for that if needed, but I mean, it's a pretty elementary point.
Yeah, we're good.
Okay, so Your Excellency, in summary, the claimant absolutely did require either permission or consent to amend. It obtained neither, and so the question is, what is the appropriate response? Our position is straightforward. If you make amendments that you weren't allowed to, the only logical sanction is for those amendments to be struck out. And there's some support for this in the English White Book. Can I take you to the Defendant's Authorities bundle, which is at section E, tab 4.
Yes.
So if Your Excellency's there, it's page 119. Final page. Are you with me, Your Excellency?
Yes, I'm just my computer's downloading the file.
Oh, okay.
Takes time. We're departing from system to system. You've heard of the quote cyber attack, and then
Yes.
that have some of bad impact on our businesses, slowing us down. Yeah.
Doesn't make
even at the internet level.
That's very frustrating.
Yeah, but we're working on it.
No.
Yeah, but it's open. Yes.
Okay,
Yeah.
so page 119. And it's paragraph 17.2.1, so middle of the page. And then it's the middle paragraph there, begins in practice most applications. And the sentence that we're interested in is the second sentence in that paragraph. It says,
sorry, what's the page? Page number 119, isn't it?
that's right.
Page 119, that is, I think you've given me maybe wrong reference, because this is a letter.
Sorry, we're in the,
Tamimi.
sorry, so it's page 119 of the defendant's authorities bundle. So, okay, 1 second, let me find out what it would be. So it's it'll be page 451 in your bundle, Your Excellency.
451.
Does that look like an extract from the White Book?
I'm waiting, yes.
I wonder
yes, it is,
oh,
yeah, I have it, yes. It's just from Rule 1740.1.4.
so no, so it's 17.2.1.
I see, yes.
And it's the middle paragraph, final sentence of that paragraph. It reads, if an amendment is irregular, i.e. made without permission where permission was necessary, so that's the situation we're in, we've got an irregular amendment, a party wishing to challenge it should apply under the power to strike out a statement of case. So that's exactly what we've done. We have an irregular amendment, we've applied to strike it out.
And you are applying to strike out the alternative case and the alternative remedies.
Exactly. Right. So we're not, just to be clear, we're not applying to strike out the entire claim. It's only the amendments that have been made improperly. Now, my learned friend cites a number of authorities for the proposition that strikeout is a remedy of last resort, and so where appropriate, a less draconian sanction should be imposed. I mean, that's obviously right as a matter of principle. It's just that in cases like this, there is no other appropriate sanction. I mean, the problem we have is that amendments have been introduced when they weren't allowed to be introduced. The only way to resolve that issue is to strike out the amendments. And so there just is no other alternative sanction. So the fact that it's draconian is sort of by the by. This is the only option available to the court to remedy the procedural breach which is before it. I'm slightly surprised by my learned friend's argument, because how else are you supposed to deal with irregular amendments? The only way to do it is by striking them out.
But have you seen an amendment allowed by the court at later stage, but in a different basis, despite the fact that there were no consent by the parties or precondition? Yeah.
So I've never actually.
I'm sure there is a basis for that.
Yeah, I mean, so Your Excellency, I've never seen an example of that happening, but I accept that it is theoretically possible if the party meets the test for relief from sanctions. So I'm going to come on to deal with that when I look at the amendment application. If my learned friend can pass the test for relief from sanctions, then he can amend retrospectively, as it were, in the same way that if you do something out of time, you can apply for a retrospective extension of time if you pass the relief from sanctions test.
Yeah.
So I mean, really, it's my learned friend to identify an authority which supports him, but I'm not aware of any example of someone doing successfully what my learned friend is seeking to do.
I see your point, yes.
So
the automatic sanction is the strikeout.
exactly, that is the only appropriate sanction. But Your Excellency, let's imagine if I'm wrong about all of this. Let's imagine that actually my learned friend is right, and just because a claim is being transferred from the small claims tribunal to the court of first instance, you can change your case in whatever way you want. My case is that that would still be an abusive process. And in order to make that good, I'm going to just take you to a couple more authorities. Can I start with AG and Barker, which is in the Defendants Authorities bundle? It's page 2, so I'll give you your reference. Sorry, Your Excellency, my system is also taking a little bit of time to load, but when we get there, page 2 of the Defendants Authorities bundle.
The 334.
If it says yes, it is. Yes, thank you.
Yep.
So this was an application for a civil restraint order, but the reason we're looking at it is because of its definition of abusive process. So if you go to it's page 7, page 339. And it's
right, yes.
The second paragraph.
Satisfied, yeah.
Yeah, I'm satisfied. And he says, 1, it's vexatious, but then he says, if you keep going down, he says, and that it involves an abusive process of the court. And then he gives a definition. This is Lord Bingham. He gives a definition for what abusive process means. It means use of the court's process for a purpose or in a way which is significantly different from the ordinary and proper use of the court process. Have you found that passage, Your Excellency?
I'm recording the reference. Yeah.
Okay, so yeah, it's the second paragraph.
But yeah.
Your Excellency will be able to find it when you produce your judgment.
Yeah, I found it. Yeah, it's in the middle of the paragraph. Yes.
So, I mean, we say that that's exactly what's happened in this case. Well, I mean, actually, we say there's a massive breach of the rules. But even if I was wrong about that, and even if this was strictly permitted under the rules, it would be using those rules for a purpose for which they were not intended. I come back to the fact that the purpose of transfer is simply to ensure that the case is heard using the proper procedure or the most appropriate procedure and before the most appropriate tribunal. It's basically just because the case is too high value or too complex for the small claims tribunal. So there's no reason in those circumstances for a person to be able to amend without permission. So even if Your Excellency referred to a loophole earlier, even if strictly there is a loophole, using that loophole would be an abusive process. And I'm just going to take Your Excellency to one more authority which elaborates on abusive process. It's the bottom right hand corner, number 90. In fact, I'm conscious I'm a little bit short of time, so we'll go straight to bottom right hand corner, page 103, and I'll give you the reference for that in a moment. Yeah, so bottom right hand corner, 103 is page 435 of the bundle. This is the case of JSV and Shuriken. Given the shortness of time, I'm not going to take you through all of it, but Your Excellency, when you come to prepare your judgment, I'd be grateful if you could have a look at this authority in a bit more detail, because it contains a discussion on the law of abusive process. And in particular, can I just draw your attention to paragraph 51, if you're there with me?
Yeah, when it's download, bear with me.
Okay.
It's downloading. Yes, it's come up.
Great. So paragraph 51. So after going through all the authorities, it says it's clear from the above authorities that contrary to one of the parties' contentions, proceedings, and I would add parts of proceedings, so in this case the amendments, can be struck down as an abusive process, even where there's been no unlawful conduct, no breach of the procedural rules, no collateral attack on a previous decision, no dishonesty or other reprehensible conduct. The power exists precisely to prevent the court's process being abused through the lawful or literal application of the rules. So, as I say, even if I'm wrong about this being a complete flagrant breach of the rules, which I'm not, but imagine if I was, the court still, it would still be an abusive process, and the court would still have the power to strike out these amendments. So, Your Excellency, those are my submissions on the strikeout application. We say, I mean, my letter for will make his submissions, but we say the strikeout application is really borderline sort of unarguable. This is the only appropriate sanction. And so then the question is just whether my learned friend should be given retrospective permission to amend. So that's his amendment application. And Your Excellency, I want to make clear at the outset, we are not saying that the court does not have jurisdiction or the power to reintroduce the amendments. This is the point we discussed earlier. My learned friend has referred to a number of authorities such as Alpha Tan and Your Excellency's decision from Abdel Salam, which show that the court does have jurisdiction to basically amend feelings of its own motion if necessary. The question is not, does the court have the power to do it? The question is, should the court exercise that power?
Yes.
And we say, no, it shouldn't. And the appropriate test that the court should apply here is the test for relief from sanctions. And I'm just going to take the court to an authority to explain why that's the case. If you could go back to the defendant's authorities bundle.
Yes, I'm in.
And
may I ask you, do you hear me clearly? Do you hear my voice clearly to your end?
yes,
Oh,
yes,
that's good. Thank you.
And it's starting at page 398. Actually, given that Your Excellency has to load the pages up, it may be quicker just to go straight to.
Yeah, although we're sharing, by the way, a same CMC system, I'm having bad internet because the whole court now using, and this is user guest internet, because
Right.
our main internet that supplied our servers are affected too. So I'm using like internet that's usually suitable for mobile only, not for offices. But it's yeah, it's there. Wolf Rock.
So
Yep.
yes, we're in Wolf Rock, and essentially this was a case in which witness statements had been served up after the deadline, and so then the party who wanted to rely on the witness statements applied for an extension of time to do so, or permission to do so. And the question was whether or not they had to meet the relief from sanctions test, and the answer to that question was yes. So, but the facts of the case are not so relevant. It's more the discussion of the authorities on this issue, and that discussion starts at page 407.
Right, 407.
And it's paragraph 17. So the judge says, on the facts of this case, no specific sanction is prescribed for breach of the orders. However, in recent years, case law is built up of the concept of the implied sanction, to which the Mitchell and Denton, i.e. the relief from sanctions principles, are equally applicable. He cites a number of authorities for that proposition. And then he goes through some of the key extracts from those authorities, which is why this is such a useful such a useful case. So if you go on to 408.
Yes.
Paragraph 20. So there's an extract here from the classic case of Sawyers and Clark Walkers. And can I just ask the court to read the quoted passage in paragraph 20 and let me know when you've read that?
Yes, after letter F.
Yes, exactly.
Yes.
So CPR 3.9 is, as Your Excellency will know, the relief from sanctions bit in CPR. And so what the court is saying there, what the Court of Appeal was saying was that even in a situation where there's no express sanction for a breach, the relief from sanctions test is still applied, because if the application, in that case, an application for retrospective extension of time was not granted, the applicant wouldn't be able to do the thing that he wants to do. And that's spelt out in paragraph 21 by Judge Paul Matthews. Brooke LJ was not saying that the intention of the rulemaker was that there should be a sanction applied. He was saying that for good policy reasons, the law should treat this application as if it were an application for relief from sanctions. And then there's just at the end there's also a passage from the Altamont case, which makes the same point. The reason given by Brooke for treating an application out of time as analogous to an application for relief from sanctions was that such an extension could not, over the page, otherwise proceed.
Right.
So then the judge ties all of these authorities together at paragraph 22. So we're now on page 409. Has that loaded successfully?
Paragraph 22.
Paragraph 22, yeah. So according to this line of authorities, I understand the position to be that although there are cases where the rule or order does not expressly state a sanction, and the court by process of interpretation nevertheless construes the rule as impliedly containing one, there are also cases where there's no intention to create a sanction, but the law for policy reasons treats the case as analogous to an application for relief from sanctions and applies the mission addendum principles. So, Your Excellency, that's the situation that we're in. We're in a situation where if the strikeout application is granted, unless he gets retrospective permission to appeal, he won't be able to include those amendments. And so, in effect, what he's seeking is relief from the sanction that the court will just have imposed. He'll be seeking relief from the strikeout. He'll be seeking to make it as if the strikeout had never happened. And so, given that what he's basically doing is seeking relief from sanctions, the court, for good policy reasons, will apply the relief from sanctions test.
I'm following, yes.
Yes, Your Excellency, I'm just looking at how much more I've got to go and judging whether or not I should take you to more parts of this authority. I think it's probably not necessary. Yes, so Your Excellency, it sounds like you have the point what my learned friend is essentially seeking to do is seek relief from sanctions by undoing the effect of the strikeout. Therefore, he should meet the relief from sanctions test. And Your Excellency, I'm sure, is familiar with the test for relief from sanctions because you only recently set them out in the Mad Atelier case.
Otherwise, I'll familiarize myself with.
Yes, I mean, I think it's worth going to. It's worth going to this. So, page 111 in the bottom right-hand corner, which is page 443 of the bundle. And just let me know when that's loaded.
Yes.
So this is your Excellency's decision.
Yeah.
If you go on to 448, maybe the scrolling down and cause it to reload.
I'm in. Yes.
So your Excellency is dealing with the test for relief from sanctions, and you start by quoting. You can't actually see the number, but I can tell you that you're quoting from Rule 4.49 of the RDC, and it says on an application for relief from sanctions, the court will consider all of the circumstances, including. I just want to emphasize a couple of these. Number one is the interest of the administration of justice. I'd also like to emphasize number three, whether the failure to comply was intentional, and number four, whether there's a good reason or good explanation for the failure. And then at paragraph 13, you say in Denton, the English Court of Appeal clarified how relief from sanctions should be approached. And you say, although the DIFC rule and the English rule are not identical, the same approach should be taken. And then you explain what that approach is. It's a three-stage test. One, is the breach significant or serious? Two, why did the breach occur? And three, whether in all the circumstances of the case, relief from sanctions should be granted. And I just want to pick out a point on the second of those elements. But I just want to pick out a point on the second of those elements by going to the case of Mitchell, which is a page. I'll go directly actually to the relevant page. Which is 352. So Mitchell, you're actually recall that Mitchell and Denton are often considered as a pair. That's why they're referred to as the Mitchell-Denton criteria. And if your Excellency just lets me know when that page is successfully loaded.
Yeah, still downloading. Yes, here we go.
Paragraph 41, the Court of Appeal said, if the non-compliance cannot be characterised as trivial, then the burden is on the defaulting party to persuade the court to grant relief. So that's important. The burden is on, in this case, my learned friend, to persuade the court that relief should be granted. And then if we go down to paragraph 43, it says in the second sentence that good reasons are likely to arise from circumstances outside of the control of the party in default. That's important. And then if we go on to the next page, which is page 353 in your bundle, I'll just wait for you to confirm that that's loaded.
Yes, I'm in.
Paragraph 48, so the final paragraph on that page. And we're interested in the bit which starts in line with the guidance we've already given. So it says, in line with the guidance we've already given, we consider that well-intentioned incompetence, for which there's no good reason, should not usually attract for relief from sanctions unless the default is trivial. We share the judge's desire to discourage satellite litigation, but that's not a good reason for adopting a more relaxed approach to the enforcement of compliance with rules, practice, directions, and orders. In our view, once it's well understood that the court will adopt a firm line in enforcement, litigation will be conducted in a more disciplined way, and there'll be fewer applications for relief from sanctions. So those are the principles which the court has to apply when considering my learned friend's application. And so, just briefly, my learned friend doesn't engage with the test for relief from sanctions at all. He treats this as basically just an ordinary application for amendment, as if the amendments were being made prospectively. And so he says, well, all I have to do is show that there's a real prospect of success. But that's not the situation we're in. We're in a situation where amendments have already been made wrongly, we say, should, and we say hopefully will be struck out. And then the application is to reintroduce those same amendments retrospectively. So the authorities which my learned friend cited are not pertinent. So if we apply these principles to the facts of this particular case, let's take the three elements of the density test.
So you rely in the sentence firm line of enforcement. Strict, to me.
We do rely on yes, the line strict compliance. Yeah, I mean we don't rely on paragraph 48 in its entirety. The key point really for paragraph 48 is even if my learned friend manages to persuade the court that their failure to seek permission was just a sort of innocent oversight, even if they manage to persuade the court of that, that would fall within the category of well-intentioned incompetence. So that's why I've taken your excellency to that passage. So let's go through the Denton criteria. The first is the breach serious and significant? Well, obviously it's serious and significant. The claimant has introduced an entirely new alternative claim without getting permission or seeking consent. This is absolutely basic and fundamental stuff, and is far more serious than, for example, missing a deadline, and even that is usually considered serious. But it's far more serious than that. The claimant is trying to fundamentally change the nature and complexity of his case, and is trying to do that and breach the rules. So that it's plainly a significant and serious breach. So the burden then passes to my learned friend to give a good reason why that breach occurred. And there are basically three possibilities, which is what I say in my skirting argument. There are basically three reasons how this situation might have come about. The first is that the claimant might simply just not have thought about it. Well, in that case, that's not a good reason, because any competent lawyer, when considering changing their client's statement of case, should be considering whether permission is required. The second possibility is that the claimant thought about it, but then reached the wrong conclusion that permission was not required. Well, in that situation, that falls squarely within the category of well-intentioned incompetence, because for the reasons we've already gone through, the construction which my learned friend seeks to put on the rules is just obviously wrong. And then the third part of the test is all the circumstances of the case. The third possibility is that the claimant knew that permission was.
So while in the second one, I mean, it's he said even if they thought about it and thought consent is not required. Let's say we're talking about their interpretation to the rules at the time, maybe.
Yes.
And you think that still should be faced with the same firm, strict sanction?
Absolutely. I mean, otherwise a party could just blame its lawyers for any breach. That's not the law. I mean, if the lawyers make a mistake, then the client, and that causes prejudice to the client, then the client has remedies potentially against his lawyers. I mean, I don't want to get into that, but that is typically the answer that's given.
How about make mistake clear rules, or make mistake based on interpretation of maybe a rule that's surrounded by vagueness and ambiguities? Would these circumstances change?
I don't think so, you're right. If the rules are unclear, then what a prudent lawyer would do is adopt the safest course, which is in this case would be to seek consent and permission. What you don't do as a prudent lawyer is say, well, there might be a loophole here. Let's just have a go at it, and then if it doesn't work out, then we'll just get away with it because the court will grant us relief from sanctions. This is.
I see what you mean.
And then the third option, and I sort of hesitate to even raise this, is that the claimant knew that permission was required, but then just decided not to apply anyway, for example, in order to avoid the cost of the contested hearing. And that would obviously be an intentional breach of the rules, and so obviously wouldn't be a good reason. I mean, I'm not going to say anything more about that. And then the final part of the test is that the court has to consider all of the circumstances of the case. And as Your Excellency saw when we looked at the relevant rule in the course of Your Excellency's judgment, this is where the administration of justice becomes very important. Because what the court is confronted with here is a party who, at best, and sort of carelessly or incorrectly, and at worst, deliberately, has failed to comply with an absolutely basic rule of the court, which is that you can't amend without permission or consent. And is now coming up with, in our submission, totally spurious arguments to retrospectively justify its conduct. What happens if the court grants that party relief from sanctions? It's sending a message to both the claimant, but also to all litigants, that, as I say, it's okay to have a go at amending your statement of case without permission, because even if you fail, you can just apply retrospectively for permission and then you'll just be in no worse position. So there's no incentive not to try to amend without permission. You can always just apply later. That obviously is not an incentive which the court will want to give litigants. The court wants to give the opposite incentive, i.e., if you adopt this cavalier or at worst sort of deliberate breach of the rules, if you adopt this cavalier approach and you get it wrong, then I'm afraid the consequences are you don't get to make the amendments you wanted to make.
Well, I see. So the court will be considered compromising. It is strict enforcement of its own rules.
I mean, exactly. I mean, it's just creating an incentive for parties to try and get around the rules, or to try and avoid the rules, which is the opposite incentive that the parties should have. So we say that the test for relief from sanctions is not met in this case. And indeed, we would actually go so far as to say that even if the relief from sanctions test didn't apply, the court should still refuse permission to amend in its discretion, given the points that we've raised. So the upshot of all of that, Your Excellency, is that the strikeout application should be granted. The amendment application should be refused, and then there'll be a conversation about costs. Your Excellency, there is you'll need to hear from my learned friend. There is a draft order at the end of my skirting argument, which you may want to consider later. Do you have any further questions from me before I hand over to my learned friend?
Not really for now. I might come back to you after Ms. Dorothy's submission.
Okay, well, I'm very grateful, and thank you for your questions, Your Excellency. Thank
you very much. I think it's maybe we can take the break earlier, like 10 minutes earlier, so we will come back also earlier. Mr. Dorothy, is it okay if we came 1:45 Dubai time?
Fine from my perspective.
Yeah, and you would have a similar time that's allowed to your opponent. I'll see you then.
I'm very grateful.
Good afternoon, Mr. Dorothy.
Afternoon, Your Excellency. Can you hear me okay?
Yes, I do. We're waiting for Mr. Cooper.
Yes, I think so.
Are you appearing from London yourself, or from Dubai, Mr. Dorothy?
I'm in the UK.
You. And I guess Mr. Cooper as well.
I'm also in the UK, Your Excellency.
Okay. London or somewhere else?
London.
London.
From Chambers.
Yes. The center of business, legal business.
Well, Dubai is fast approaching, isn't it?
Yeah, but we can't forget the solid base of legal hub and judicial hub. Yeah.
Well, that's very kind.
We're trying to take a marketplace only from sharing a little bit. Yes, it's Mr. Dorothy's time to submit about to oppose the strikeout and then to submit why his application should
Yes, Your Excellency. Thank you. You'll have obviously had the opportunity to read my skeleton, and it's not going to come as a big surprise to you to say that in our submission, the defendant's position on these applications is a bad one. And there are a myriad of different reasons for that, and you can cascade your way through the different turns at which the defendant fails in his position in this case. The first point is that it's misunderstood what the rules say happens when a claim is transferred from the small claims tribunal to the court of first instance. And that's this issue about it being a fresh claim. And the defendant tries to dance around that somewhat fundamental problem. But as I'm sure Your Excellency is aware, that's a requirement that was introduced into the DIFC Court's rules relatively recently by the Chief Justice in May 2021. Those amendments were made for a reason and must be given effect to. The second point is that this is a case where both parties put their minds to the terms of directions which were going to be issued by the court after its transfer to the court of first instance. I'll come back to some of the excerpts from the correspondence later. But the primary position is that what we say happened and what was in the contemplation of both parties at the time that correspondence was exchanged was that what was going to be filed was a claim form that was not the same as the claim form that had been filed up to that point in time. And together with that, particulars of claim, which would obviously be fresh because, of course, no particulars of claim had been filed in proceedings at all up to that point. And that approach, for reasons I'm going to come to as we go through the relevant provisions of the rules, is not only consistent with RDC Part 53, but it also intersects seamlessly with what's set out at RDC Rule 18.1. and I'll come on to the detail of it, but effectively, if you are a claimant in the court of first instance and you have not yet served proceedings, you haven't served the claim form, you haven't served particulars of claim, Rule 18.1 says you're at liberty to amend without consent and without permission. And the point of those rules and their interaction is that if you're in the small claims tribunal and you're transferred to the court of first instance, you are and should be in exactly the same position as a claimant in the court of first instance. So you shouldn't be at a disadvantage or put into a worse position simply because your claim has been transferred. And as I say, there's not only the rules, but there are case law underpins to that position as well. The third broader reason the defendant's application for strikeout is misconceived is because even if you ignore what the rules say, even if you ignore what the parties had said up to that point, and even if you assume what, in my submission, is the defendant's best possible case, i.e. there is a technical non-compliance with court procedure, largely arising from the fact that there appears to have been no meeting of minds between the parties, or they were talking across each other in this correspondence. And what one party meant as an amended claim form was different to what the other party meant by an amended claim form. Even if you take all of that, we are still miles away from this being an arguable abusive process. We're miles away from this being a case where there's a sufficiently serious and significant breach to justify the strikeout of a meritorious claim. And even then, Your Excellency, the claimant has taken protective steps in relation to what the defendant had perceived to be non-compliance with court's rules, in that when the issue was flagged, it promptly filed an application to amend. And to be clear, the claimant says it didn't need to file that application at all. It's done so as a method of addressing the defendant's perception of non-compliance in order to be pragmatic and to try and carve a path through these issues which avoids an unnecessary contested application. And we say that the only real question for Your Excellency on the amendment application is whether or not the claim as amended has prospects, and the defendant hasn't at any point articulated a case as to why it doesn't, and still doesn't make that case. So what should we say have happened, both as a matter of good practice, but also in accordance with this court's express rules on amendment applications, is that it should have been consented to. I'm sorry to say that that hasn't happened. The reason we say, Your Excellency, that hasn't happened is because the defendant is taking an opportunistic stance in these proceedings. There are two components to that. One is what you might see as the usual opportunistic attempt by an over-aggressive defendant to jump on a perceived non-compliance for tactical reasons. But the second point, which I'm going to go through in just a moment, is the particular circumstances of this case are such that the longer the defendant can drag them out, the longer it can continue to occupy the claimant's premises and operate its business rent-free. So that's a snapshot of why we are where we are. The way I propose to tackle those submissions in detail is first to take Your Excellency to some of the background, that is to show you what the claimant's case is, how that's come about, and most importantly, why it's a meritorious claim. Certainly something the defendant hasn't leapt up to dissent from at any stage so far in these proceedings. The second is I'll take Your Excellency to the relevant principles on strikeout, and in particular what Part 53 says about reallocation to the court of first instance. And the third is I'll address Your Excellency on amendment insofar as it's necessary for us to actually go that far, because of course, if we're right about Part 53 and if we're right about Rule 18.1, the amendment application probably falls away. So as I say, that's a snapshot. I'll jump into that in the order I've suggested. So turning first to the broader background to this case. If I can ask Your Excellency, first of all, to go to page 63 of the bundle.
Yes, I mean, yes.
you'll see that this is the particulars included at what that time was intended to be a CFI claim form. My learned friend already took you to the replicated version of that appeared in the SCT and was served. And under what was at that time the particulars of claim, we see the basis of what is a pretty straightforward claim. So what it says is the defendant was the tenant of the claimant's premises in Emirates Towers. It was using those premises to run a restaurant called Crab Market. We have a lease agreement which provides for the provision of rent, accruing at a rate of 6,000 dirham a day. Since February 2022, the defendant defaulted on payment and even allowing for some part payments in the magnitude of around $500,000 dirhams, so 500,000 dirham. There was still outstanding rent up to September 22 of that year of just over 900,000 dirham. And the consequence of that is because arrears thresholds specified in the lease had been surpassed, the claimant terminated the lease and sought vacant possession. What then happens is the defendant fails to vacate, so the claimant has sought liquidated damages under the terms of the lease until such time that the premises were given up. And we can see all of that, of course, reflected then at the statement of remedy sought at the bottom of page 63. So it's asking for vacant possession, rent arrears, liquidated damages, and some other administrative fees under the lease. From that point, Your Excellency, you'll have seen, so this is my skeleton argument in paragraphs 15 and 16. What happens procedurally is this claim is transferred to the Small Claims Tribunal. But you'll also have seen, Your Excellency, what the defendant didn't do at this juncture was file a defence, which, even allowing for the flexibility that's built into SCT procedure, is the normal course under Rule 53.14.2. So the parameters of the defendant's case weren't actually known to the claimant until Mr. El Amin filed a witness statement in mid-February 2023. That witness statement, should Your Excellency want to go read it, has been added to the bundle. It's at section E, tab 8. But just to summarise the points that were raised there, what Mr. El Amin says is he has a number of allegations regarding his former business partner in Crab Market and a number of other restaurants. That's Miss Swarthia. He also asserted that a number of payments totaling 1.7 million dirham had been made from the bank account of a third-party company. So this is a company called Kotleta, which is a different restaurant. So 1.7 million goes from Kotleta to the claimant, it said. And so those amounts should be seen as standing as rent payments. But in any event, what Mr. El Amin said in his witness evidence, and as was set out in the defendant's skeleton argument for the SCT hearing, what he actually wanted was for proceedings to be stayed or adjourned off. And that's what the defendant argued for at the hearing listed before the SCT judge. Just pausing there for a moment to flag one point which Your Excellency might consider to be of interest. As I already said in my skeleton argument, there's an obvious oddity in a defendant adopting a position where it wants proceedings to be stayed. You might think that if you're a tenant and you're clear in your own mind that you've paid your rent, you would want the court to make that finding and dismiss the claim being brought, you would say, wrongly by the landlord. But that's not where we are. Where we are is the defendant is seeking to make use of the court's discretion, again, in order to kick the can down the road, hopefully on its case for an indefinite period. And when one asks why a tenant in that scenario might adopt that strategy, it isn't difficult to see the potential upside to a defendant of remaining in possession of premises operating its restaurant, presumably for profit, without having to pay any of its rent overheads, and to be able to continue in that position until we have trial, judgment, enforcement, and who knows after that what difficulty recovering arrears from a business that was already struggling to pay its rent as far back as February 2022. So you're on mute, Your Excellency.
You have not applied for evacuation, isn't it, or eviction?
In the claim
application, isn't
it? We are seeking declarations of termination and vacation of the premises as part of the relief sought in the CFI proceedings.
The main claim, yeah.
Yeah.
I see.
So, Your Excellency, putting that to one side, what then happened in the SCT proceedings is we have Mr. Nawal Swathia providing a statement on behalf of the claimant, explaining, amongst other things, why the payments that were made from this Kotletta restaurant business were actually payments of costs and operational expenses with respect to a number of different restaurants situated in different places of Dubai. So things like staffing costs, alcohol purchases, all itemized with receipts and set out in his statement. And of course, if Your Excellency wants to go look at that, it's section E, tab 9. I won't go to it now. So in short, the evidence, what's going to be argued at trial, is to say that the 1.7 million wasn't a rent payment, but Your Excellency doesn't really need to be concerned with that issue today. The parties then go to the SCT hearing. The judge decides to transfer the case to the CFI, which I'm going to come on to the procedural effect of in a moment. Before I do, it's worth highlighting the central problem with the defendant's case and how it's advanced its position on the merits of its case. So the claimant's assertion is between February and September 2022, the defendant is 900,000 dirham in arrears after offsetting rent payments in part payments. The defendant's position, even if you start from the basis that everything it's saying is correct, is that he has paid 1.7 million dirham and that those should be deemed to have gone towards his rental obligations for that period of time, rather than payments to other restaurants and other entities for their operational costs. And if you assume for the sake of argument that the defendant is right about that, as far as that can get him is that he's fully paid up in rent up to September 2022 when the termination notice is issued. But, and this is the key point really, it isn't even disputed. There is no assertion at all before the court that the defendant has paid a single fil or a single dirham in rent since September 2022. So if his best case is that he paid up until September 2022 and therefore the termination of the lease was premature and that he was still entitled to remain in possession at that point in time, the defendant still has to pay its rent. It's still in possession of proceedings of premises. It's still operating a restaurant there. Its Instagram profile is still posting daily stories about events they're holding there. And so if you go from September 2022, where there's no evidence of a single payment being made, to the date of today's hearing, the unpaid rent between those dates would be somewhere between 1.5 million and 2 million dirham. So that's even taking into account what's said to be paid. And there is no answer to that problem from the defendant at all.
Yeah, it's almost 10 months today, yeah, isn't it?
Yes. So really the point is, even if you take the defendant's best case, all it gets it to is being paid up until September. It still has an obligation to pay rent after September because it's still in possession of the premises. And that's the context of the alternative claim, because the alternative claim in effect says, okay, if you're going to argue that the termination notice is invalid, then you still owe us rent. And I'll take you through that, Your Honour. If you look at page 69 of the bundle,
to your particular claim?
That's right. So we have the particulars. So first of all, we have paragraphs 3 through to 5. those set out the relevant terms of the lease that apply and tell you when you're in arrears of rent and what the entitlements are if you are in arrears of rent. If you scroll down to page 71, from paragraphs 6 through to 12, we have the explanation of why they've fallen behind on payments and which terms of the lease those give rise to breaches of. So it's the financial position. And then when we get to paragraph 13, it starts with the rent arrears as they stood at the point in time of termination and why the claimant was entitled to terminate the lease. So that's paragraphs 13 through to 18, which specifies if you're in arrears of more than 180,000 dirhams, we can terminate. If we terminate, you have to vacate. If you don't vacate, we're entitled to two things: liquidated damages and administrative charges as a consequence of that. And so that's where we get up to paragraph 18. Now, of course, at the SDT hearing, where a skeleton argument was provided by the defendant, who hadn't yet provided a defence, what we had articulated by the defendant for the first time was this idea that he had paid up rent, that he paid the 1.7 million, which begs the question, well, even if he's right about that, he's still in breach. And he's still in breach for all of the same reasons we assert he was in breach before. It's based on the same terms of the lease. It's based on the same factual premise, i.e. you owed this 6,000 dirham a day and you didn't pay it. And the only distinction between the claim and the claim that's pleaded in the alternative is a question of at what point in time is the lease terminated. So on the primary case, we were entitled to terminate in end of September 2022. In the alternative claim, it says that we're now entitled to terminate even if we weren't back then. So what we're asking the court to do is to terminate it now, even if it wasn't entitled to terminate back then. So just to pause there, we're not even dealing with a new claim, as my learned friend somewhat dramatically put it earlier, to suggest that we were entitled to plead what we want. We've pleaded a completely different claim. We're nowhere near being in that sort of territory. What we're saying is, if the assertions made by the defendant at the SCT hearing regarding the validity of termination are correct, you still owe your rent based on the same provisions of the contract that we've already relied on in the claim.
Yeah, Mr. Doherty, before you go further, I think there is a lower threshold. Well, if you want to amend, we understand your amendment must have stuck to your original claim form, or at least the granted cause of action in your hand. So when it comes to this, let's talk about, you have a claim form, you have unsubstantiated claim form, you need to particular as your claim. You need to change your particular claim. You still need to have your opponent consent. If your opponent is not collaborating with you or not being sensible with you, then you can go to the court and say, well, Mr. Judge, we would like to make changes. This changes is supporting our position. We have the sole right to do so. We have the basis. We're still within our cause of action. We're still bound by our claim form, but there is some details and some new powers to come. And if that's how it's work. I mean, isn't that the understanding? If you need to do any changes to the submissions, whether it's a serious ones, normal one, elaborating one, you still have to approach your opponent and the court to do that. And now whether with this amendment should be in compliance with the claim form or the cause of action given to you based on the first statement of case, then that's another issue. That's for the court, first for your opponent and then for the courts to review. But do you see where the point stands? If you need to do amendment anyway to your statement of case. You have to seek consent or court order. Yep.
Yeah, sure, Excellency. The answer to the question. Can I just check if you can hear me? Your feed was breaking up slightly when you were speaking, and I don't know if it's me or if it's on your side. But if I do break up,
hear you. I can hear you clearly. Yes.
If I do break up, please just tell me.
Yep.
The answer is, if you are in circumstances where Rule 18.2 applies, that is correct. But if you're not in the circumstances, which is where this case, and Rule 18.1 applies, and Rule 53.41 applies, you don't need to go to the other side and seek consent. So, I mean, really, here's the artificial.
Which is the service.
Yes, of course. And really, here's the artificiality of the defendant's position in some ways. Because let's say, for the sake of argument, we had already filed the particulars of claim. Let's say we'd filed it only up until the end of paragraph 18. And we'd served that together with the claim form. And we then made an application to amend that the other side didn't consent to.
Your voice is breaking out now.
The court would say,
I don't know if you hear me, Mr. Dory.
Well,
I cannot hear you clearly.
Do the amendments have prospects? Is there any?
You're gone, Mr. Doty. Mr. Doty, you're gone. Can you hear us? We cannot hear you. Your picture's freezing.
I've started to hear you. It appears to have.
Our CPO suggesting that you log out and log in again. Mr. Doty, if you hearing us.
Excellency, can I check if you can hear me now?
Yes, much better now.
Good. I'm attempting a different connection. I don't know what happened there. It was fine this morning, but as is always the case.
Yeah, it could happen. That's possibly happening. The last things we hear from you, the distinction between if a claim form being served or not, and you have served up to the Article 18 of paragraph 18 of your statement of case.
Yes. So the point is that there are circumstances in the rules where if you want to make an amendment, you have to either seek consent or you need to go to the court and make an application. Those are the situations dealt with under Article 18.2, which is when a claim form and particulars of claim have already been served. At that point, you're not at liberty to amend. But the position is different if you haven't filed and served the claim form and particulars of claim. And the situation is also different when you have been transferred from the small claims tribunal to the court of first instance. As I say, I'll come on to the detail of that The point I was making, I think, just before I broke up, was to point towards the artificiality of the defendant's position when you step back and view these applications as a whole. Because if the pleadings had been filed, as I say, even if they had been filed and served only up to paragraph 18, and the very next day an application had been made to the court to amend, and 19 to 24 were inserted, there would have been no grounds at all on any analysis for those amendments to have been rejected, for there to have been a hearing, and so on. And the
Sorry,
point,
sir, just to follow up from that, you're saying there are three different circumstances. In ordinary circumstances, amendment before service, amendment after service, and then there is a third situation where a case is transferred from the SCT. So what have been
yes,
served is a SCT documents, not CFI documents.
yes, really that's an extension of the first example, because
Yep.
the effect of the rules that I'm going to come on to are that once it's taken out of the SCT and it becomes a fresh claim, it means that you have to take the CFI steps. And it's not just the steps that my learned friend wants to take with disclosure, it's all of the steps. So it's filing and serving. And that's what the rules say. So once you've been transferred, it puts you into the same scenario as if you were a claimant applying Rule 18.1, i.e. at liberty to amend your claim form prior to service without consent and without permission of the court. That's how the rules operate, and there's a good reason that they do operate in that way.
I see.
Just pausing again on.
So you just disregard what have been submitted before the SCT. It's whether you have served claim form, particular, or whatever.
Yes,
So
it's a fresh claim, and that's what fresh claim means.
You are put in a new situation where you can plead freshly in your submissions.
Yes, and in the same way that the defendant wouldn't be constrained to only take points in defence, the points that it had either pleaded or put into its skeleton argument before the SCT. So you're putting the parties in the same position.
Is that your own interpretation of the rules, or you're referring me to a authority?
I will do both in just a little while, and to take you through that.
Right.
But as I say, just again stepping back and pausing for a moment, if the alternative plea was to be struck out here, it would leave proceedings in a frankly somewhat preposterous situation where if the defendant goes to trial and manages to prove that he had paid the 1.7 million he says he paid up to September 2022, he'd be in a situation where he can nevertheless get away without paying any rent from September 2022 up to trial. Worse than that, it would leave the defendant in a questionable situation with his ongoing obligation to pay after trial, because it obviously can't be right that he's allowed to remain in those premises with an indefinite right to possession without making payment of rent. That would be a legally absurd outcome. Even more so, Your Honour might think, where the defendant's strikeout application and the position on these applications more broadly is that he doesn't even try to put forward a reason why the claim as pleaded, including the alternative relief, has no real prospect of success. And the reason for that is that the defendant knows full well, whatever way it fits its case, it's faced with the inescapable reality that is going to owe the claimant a substantial amount of money. And that's why we say we see this opportunism. That's why we say we find these repeated attempts to drag out proceedings for as long as possible. And that context and the merits of the claim are relevant, not least if Your Honour actually gets to the point of having to consider what's in the interests of justice in this case. Because clearly the interests of justice here, where we're dealing with, at best, technical non-compliance, weighs in favour of allowing the claim form, in particular's claim, to stand as pleaded. as I say, Your Excellency, that's the overview of the case and how we've got here and what the motives are, why you're faced with this contested application at all. But it brings me on to my submissions on strikeout, which say we don't even really get to that point of the court needing to exercise a discretion. Essentially, there are 3 points in this. The first is that the SCT's reallocation procedure means that the claim form and particulars of claim were filed entirely in accordance with the court's procedural rules, as that they were a fresh claim. The second point is that in any event, those documents were filed in accordance with the directions issued by the court following the agreement of the parties, and the court's order, by its very nature, permitted the claimant to make the changes it made under RDC 18.1. And the third point is that even if one took the view that there was non-compliance, it is hard to think of a more minor or trivial example of non-compliance than the one before the court, particularly in circumstances where attempts have been made out of an abundance of caution to cure that non-compliance. So this is therefore the type of case, and the defendant should know that this is the type of case where the court would cure the issue and allow the case to proceed as pleaded. And on that basis, there is no conceivable argument in favour of striking out on grounds of non-compliance or as an abusive process. The starting point in the analysis, just to come to the first point, is if I can take Your Excellency to page 90 of the bundle.
Yes, the order from the city.
That's correct, Your Excellency. So this is the order issued after the closure of the SCT proceedings. And you see it's the last of the recitals. And upon reviewing Rule 53.41 of the rules of the DIC courts, it is hereby ordered that the claim shall be transferred to the DIC Court of First Instance in accordance with RDC 53.41. So the starting point has to be, well, what does Part 53 say? Your Excellency can find that if you have a screen with it open at paragraph 30 of my skeleton argument, or if you go to your provisions of the rules, if that's easier.
Yes, I'm in there.
And it says, where appropriate, the SCT judge may issue a reasoned order that the small claim be transferred to the Court of First Instance to be progressed as a fresh claim under the procedures followed by the CFI. And just to pause there, it's not saying to be progressed following some of the procedures followed by the CFI. You're filing a fresh claim under all of the procedures followed by the CFI. And whilst the defendant might wish that it can pick and choose which of those procedures apply, say when it comes to pleadings or disclosure or whatever, part of the CFI's procedure is...
This to be progressed as a fresh case or claim is the new amendment to the previous rule, isn't it?
It is, and I'm going to take Your Excellency to that as well as to some case law that shows us where the distinction lies. Before I do that, just to highlight while you're still looking at paragraph 30 of my skeleton, the sub paragraphs 4 and 5 in particular, where some of the matters that the SCT judge will have regard to is the likely complexity of the facts, law, or evidence, and the number of parties or likely parties. Now, a few obvious points stand out from just a normal reading of the rule, which is the filing in the CFI after a transfer from the SCT is explicitly required to be progressed as a fresh claim. As I say, that was introduced by the Chief Justice in May 2021. And I've set out what the old Part 53 says at paragraph 34 of my skeleton. And what old Part 53, it was Rule 37, said was where appropriate, the SCT judge may order that the small claim be transferred to the court of first instance. When deciding to do so, the SCT judge will have regard to the following matters. So someone has looked at the rules and decided, indeed the Chief Justice has looked at the rules and decided, to include those words to be progressed as a fresh claim. So those words are plainly intended to carry some effect, otherwise the amendment would be superfluous. And we can see the difference in the effect between the old rule and the new rule if Your Excellency looks at the Alcaire capital case. That's at page 197. I take it Your Excellency doesn't have an either. My platform is still searching for page 197.
Me too. Yeah, just come down, yes.
You have it now.
Yeah, I got it, yes.
So this is a 2020 case, so it's under the old rules. There has been an order reallocating under what was then RTC 53.37. And we can see from the recitals set out in the order that what the claimant does is go to the court of first instance and issue a new claim form. And Your Excellency, this touches, I think, on a question you asked earlier of my learned friend, which is there a restriction in bringing a new claim after you've been transferred from the small claims tribunal? And what this order is telling us is no, there is no restriction preventing you from doing that. And there wasn't under the old rules. And that's precisely what happened in this case. So a new claim was filed and it was allowed to proceed on that basis. The important point in the context of this set of applications is what the registrar says in paragraph 1, which is given that CFI 070, so that's the newly filed claim, and she says is filed as a fresh claim and is not administratively a transfer or reallocation from the small claims tribunal pursuant to RDC 53.37, so the old rule, the claim form in CFI 070/2020 stands. The point is that the registrar distinguishes there a fresh claim, in quotes, which in the context of that case meant the issuance, filing and service of a new CFI claim form, with what was back then seen to be reallocation under old rule 54.37, which was not the same thing as filing a fresh claim. So when one is looking at the rules and asking, as Your Excellency is being required to do, what does rule 53.41 mean when it says fresh claim? And what this direction from the registry is telling us is that a fresh claim is something that has been filed anew, or is to be treated as being filed anew in the CFI for the first time.
Yeah, but this remains a registrar decision, isn't it?
It is, but it's the context, I think, in which one can view the amendments to the rules being made. So whilst under the old rules, there was no restriction on reallocation to simply refiling a new claim before the CFI. The point is, with the rules as they are now framed, you don't need to do that because rule 53.41 has that automatic effect of meaning that upon reallocation, you file as a fresh claim. And the reason why that rule was introduced should be relatively easy to decipher. Claims before the SCT progressed without the same formality, strict procedural requirements, and at times without the legal representation you would expect in the CFI. And to give the obvious example in this case, when it was before the SCT, the issues were largely addressed by the claim form, but responded to in evidence. So we don't have particulars of claim or a formal defence or a reply to that defence. So the point is to make sure the claims come before the CFI have been put together properly. And that's why the way it's done under the rules is the case effectively restarts. And that point is made explicit, in case it wasn't obvious already, in RDC 53.42, which again ties in with the registry direction we just looked at. I've set it out at paragraph 31 of my skeleton argument. And what Rule 53.42 says is that a claimant in an SDT claim that has been transferred to the CFI in accordance with 53.41 is at liberty to pursue its claim in the CFI by filing a Part 7 claim form. So if a case is transferred by the SCT, what you do and what you are completely at liberty to do is to file a Part 7 claim form. The rule doesn't say you should refile the SCT claim form just in the CFI. And we know it doesn't say that because what we're doing is starting a fresh claim. And it's difficult in my respectful submission to interpret those provisions any different way, or to make sense of the court's decision that to include a requirement for a fresh claim if the defendant's position were to be correct. The defendant's case seems to be, well, you can't add anything to your case after transfer. And there are a number of reasons we say that assertion must be wrong. The first is perhaps an obvious one, and what I've already alluded to. It would give the defendant an unfair procedural advantage if, for example, in this case, the claimant's case is being limited to the substance of what was set out in its brief details of claim, but the defendant, by virtue of its own failure to file a defence in the SCT, is essentially at liberty to say whatever it wants for the first time in its defence. So there's no parity between the parties there. The defendant isn't being tied to the arguments he raised before the SCT. So the question is, why should the claimant be? The second point is the defendant's interpretation would make a bit of a mockery of the requirement for a fresh claim, because it would in effect require the claimant to proceed on the basis of his brief details of claim alone. And one can clearly see circumstances where, if all you have before the SCT is a brief details of claim, for example, as would happen in some cases, drafted by a litigant in person, when that's transferred to the CFI, if they then bring on legal representatives, they're in effect tied to whatever was pleaded by that litigant in person. And whatever amount of detailed particularization they set out in the particulars of claim, defendants are going to challenge those. The third point is that we have even further pointers towards this being the effect of the rule when we look at the terms of RDC 53.41, particularly subparagraphs 4 and 5, which refer to the exercise of the SCT's discretion having regard to the likely complexity of the facts or the likely parties. And so those points necessarily envisage that the claim before the SCT at that juncture need not be the claim in its final form in the CFI. The pleaded facts can change, even the parties can change. And to be clear, that's no different than if the SCT proceedings didn't exist at all and you've just started a claim before the CFI, because both Part 18 and Part 20 allow a claimant who hasn't filed and served to amend and to add parties. And it doesn't need the permission of the court to do that. Indeed, if one looks at it in an even more conceptual perspective than that, by its very nature, the addition of a party, even if it's the same factually pleaded cause of action, is the addition of a new substantive claim, because it's a claim against that party that wouldn't have existed before the SCT, which now exists before the court of first instance. So if you're allowed to introduce a new substantive claim against a new party, it's difficult to see why the rules wouldn't also permit the addition of an alternative basis of claim or an alternative set of relief against an existing party once the proceedings are then commenced in the CFI as a fresh claim. And my learned friend's rebuttal to all of that is to say, well, you know, this would all just make the rules impossible for the court to deal with if you were at will to change your case as you saw fit. But that submission doesn't really work, because the whole point of the rule is that the case starts afresh and the court is being presented as if for the first time by a claim. So we still have to file, we still have to plead, we still have to defend. So the court is in no different a scenario as to if the originating claim has just been filed in the CFI. There's no procedural prejudice, there's no procedural impracticality.
But isn't it true that, I mean, this complexities or number of parties, like where the SCT just decided it's the reason for the transfer, is this a factors that must be taken during the SCT? So the complexities or the number of parties that appear with the result already named, or there is an application to name them, so to appear before the SCT judge or registrar, that there is already complexities or a huge number of parties. It's beyond the control of SCT procedures, or it will defeat the purpose of doing a swift proceeding, not to wait. I mean, the complexities or the number of parties or whatever is not something we need to see at the CFI level, but something need to be proven before the SCT judge. And
yes,
once that's proven, then you will be transferred with that complexity, will it travel along?
Yes, Your Excellency. So the decision to be made by the SCT is as the case appears to them at the time they review the file. So the references to these likely is an acknowledgement of the fact that we're seeing the claim as it exists now, not the claim as it will exist in final form in the court of first instance. So taking into account what we know now, is this too complex for the SCT? The SCT can then make that decision. And it's probably also worth bearing in mind that what we're dealing with in this case, for example, the SCT hasn't said, well, look, here's a claim for rent payments. It's been complicated by some of the defendant's defences. I'm going to transfer to the CFI. We're not now coming back and filing an employment claim. You know, the substance of the claim is the same. It's based on the same provisions of contract. It's based on the same factual premise. The only thing that has changed is a timing question.
Yeah, but your argument to file completely a fresh case might have that infringement, you know. I mean, you're just giving yourself a very wider powers to file a fresh claim. The cause of action might change, the parties might change. You might add extra complexity to the one discovered already by the SCT. That's your interpretation to a fresh claim, isn't it? First of all.
Well, yes, Your Honour, I think that is right. It needs to be treated as a fresh claim from a procedural standpoint. Now, the reason that doesn't really create a practical difficulty for the court is because by the time you're then transferred to the CFI, you're in absolutely no different a position to a claim that originated in the CFI but hadn't been served yet would be. So to give the example from this case, my learned friend earlier took you to the first claim form filed by different representatives, which is Section A of the Bundle 1, where we have Sumit Ahuja and Mr. Al-Amin named as the parties. That's amended under Rule 18.1. We have a number of purported amendments to the claim form under that, none of which my learned friends takes issue with. So conceptually, the defendant accepts that you can make those sorts of amendments provided you haven't filed and served.
Yeah,
and
but
indeed, my learned friend went.
Then he objected to the alternative claim only. To the parties naming, isn't it?
Yes, and no doubt if we changed the parties, he would have objected to that too. But there's no objection when it comes to the earlier iterations of the claim form. It's just that the rules appear inconvenient to the defendant now, and that's why it's taking an issue with all of this. I suppose to put it in different terms, why should a party who has been transferred from the SCT be put at a procedurally disadvantageous or procedurally worse position than someone who's just filed in the CFI in the first place, where they're at liberty to change their claim form any time up until service? So that we say that application of the rule would plainly be a wrong one, particularly when you have regard to what the rules expressly require and what the policy intention behind that is, i.e., let's make sure that everything is started again properly.
Yeah, you may go on.
So what the defendant hopes to show you, indeed what the defendant at a minimum needs to show you, is that the claimant hasn't complied with court rules. But we say that that analysis can't work, because as I've shown Your Excellency, what the rules told the claimant it had to do, so it's not as though this is a discretion, you may start fresh proceedings. The rules say they shall be brought as fresh proceedings. That's RDC 53.41. That has the effect of restarting proceedings. Rule 53.42 expressly says that when you're in this scenario, the claimant is at liberty to file a Part 7 claim form and particulars of claim in the same way as if you were dealing with a new claim. And so the starting point on this strikeout application, on both of these applications for that matter, is that there isn't a breach of rules. The claimant did what it was entitled to. In fact, the claimant did what it was required to do in accordance with the court rules. And I'll circle back to this later. But even if, for the sake of argument, I was wrong about that interpretation of the rules, which of course we don't accept, but Your Excellency was of the view that at the very least the rules are ambiguous and one can understand why there's a disagreement between the parties about how these rules should operate. That's obviously also a relevant factor in the exercise of the court's discretion on strikeout.
Where you located this argument in your skeleton argument?
Sorry, which?
About this article, new article 53.2 you just mentioned, or 3?
53.42. Bear with me. Let me just open up my. I'm just waiting for my skeleton to load. Yeah, so you'll find paragraph 30,
yeah.
53.41 referred to then in paragraph 31, 53.42, which says a claimant in the SCT claim that has been transferred to the CFI in accordance with 53.41 is at liberty to pursue its claim in the CFI by filing a Part 7 claim form.
Yes. So paragraph 31.2, isn't it?
Yes, so the rule is set out at 30. The rules are set out at paragraphs 30 and 31. The effect of the rules is set out at paragraph 32. So it's, if you transfer from the SCT to the CFI, you must progress fresh claim. That's 53.41. For the transfer claimant, you're at liberty to file a fresh claim form, as though the case has been newly brought. That's 53.42. And so what the rules clearly contemplate, both in that provision about being at liberty to file a claim form, as well as the fresh claim, the requirement for the fresh claim is that you're not bound by your SCT claim form, because otherwise those rules would have no effect at all.
Yes.
So that's limb one. That's why what my learned friend says and what the defendant says is wrong. And it's why they can't form an argument to say that there is non-compliance with court rules here. Because as I say, what happens in the end is in compliance with those provisions. There's another route that takes you to precisely the same place. And there's a good reason for that, which again is that the rules in RDC 18.1 are intended to dovetail with what's set out in Part 53. So this deals with the scope of the court's order for directions on filing. Now, if I can just, before I turn to that, pick up a brief point in reply to something the learned friend says. One of the arguments made is that the applications are pursued by the claimant on an inconsistent basis, because we're saying that we both received consent to an amendment, but also we weren't required to amend at all. I think I can deal with that point briefly, because given what Your Excellency has already heard, my learned friend has not understood the basis on which the claimant has presented these applications. We are not saying that we needed the defendant's consent to make the amendment. What we are saying is that the parties negotiated the terms of the court's order, which was obviously issued by consent, but that the scope of that order was one in which both parties had contemplated that what was going to be filed as the claim form was not going to be the same as the SCT claim form. So the point is that we weren't seeking their consent to hear our 3 new introduced paragraphs in the pleadings. What we're saying was consented to was the scope of the order that was ultimately made by the court, which is what entitled us to make the amendment under RDC 18.1. So just to take Your Excellency through that. As I say, if we can go, Your Excellency looked at the correspondence earlier. I'll just read it out to remind you of the salient bits.
Yeah.
But the history in which the order was made is that first we have, for your note, page 153, which is the letter from the defendant's representatives, saying the claimant shall file and serve 1, an amended claim form in P701 format, and 2, particulars of claim by the 12th of July 2023, which is, and so on. So what the defendant's own letter states, or at least on one view can reasonably be read as stating, is that what's going to be filed and served is not the same claim form that's already been filed and served in the SCT. Otherwise, what would be the point of making a direction in those terms? You'd have simply said the SCT claim form stands as the claim form in the court of first instance. So both parties are contemplating the need to file and serve a claim form. That's the core point.
Yeah, I mean, you didn't have to take things out of its context. I mean, it could be sometimes just agreeing on the timetable itself only, or could be agreeing in how to pursue, let's say, understood procedures. I mean, consent is, we know consent is consent. You know, like if you to apply 18.2, what would you do? How are you going to do it? You're going to propose amendment. You're going to put amendment before you party. You're going to tell them this is an amendment to our submission. We're seeking your approval. Then they said yes or no. Then you take the other way.
Yeah, agreed. But the point from the claimant's perspective is it never considers that that's what it has to do, because its reading of the rules and its reading of the order, which I'm going to go through now, is that it didn't have to do that. When the other side alerted it to the fact that it considered it did, I'll come on to this, but it took steps to try and rectify that issue. So I think that the point is that what's not being contemplated, even in the defendant's originating letter, is you shall refile and reserve the claim form in SCT. Or for that matter, they're not saying you should refile and reserve what was an unamended but unserved claim form in the CFI. And the response then comes from the claimant solicitors, again for your note, it's at 144, which says we expect to be in a position to file and serve the amended claim form and particulars of claim by 4 p.m. on Friday, 16th of June. So again, what we're looking at is something that is contemplated to be different to the SCT claim form. And then we have the proposal of some drafting. So paragraph 1 is the claimant is to file and serve the claim form and particulars of claim by 16th June. So the suggested terms in which the order has been drafted, in my submission, are entirely consistent with the claimant's understanding of the effect of Part 53 that we've just looked at, which is we need a direction for the filing and service of the claim form, i.e. these are fresh steps that need to be taken in the CFI. It didn't need to say it shall file an amended claim form and particulars of claim, because that is inherent in the fact that what's happening here is the filing of a fresh claim. And to that extent, Your Excellency will also note that the drafting doesn't include some specific reference to the amendment purely being in Form P701. The terms of the order don't say P701 at all. So there's no support for what the position the defendant is advancing is. And when we have the defendant's response, it's at 145 for your note. They come back with some issues on timing, i.e. we want another 14 days for our defence, but it doesn't seek to suggest that the terms of the draft are not apt to cover what the parties have been discussing up to that point. And so that's what we get as the order issued. It's page 93 of the bundle. And like I say, this isn't intended to be a reflection of some order by consent under 18.2. It's a set of directions that reflect the defendant's understanding of the procedural state of play as it existed following transfer. And so what the order says, first of all, is in the recitals, and upon the order with reasons of His Excellency Justice Nestor Al-Nasser on the 2nd of June, which ordered that the claim should be transferred to the DIFC Court of First Instance, and 2, the party should file and serve an agreed timetable, it is ordered that, and then paragraph 1, the claimant is to file and serve the claim form and particulars of claim by the 16th of June. That order in paragraph 1 has to be read in the context of the recitals, which records why this step is necessary, i.e. there has been a transfer under 53.41. This now has to be progressed as a fresh claim in the CFI. And so we have an order that the claimant is to file and serve not just particulars of claim, which of course haven't been provided to that date, but also the claim form. And so that drafting is perfectly apt to cover what actually happened in this case, which was the claimant filing and serving, whatever way one analyses it, either a fresh claim, or if you take the view as an amended claim form, and both are caught by this wording and the expressions of intention of the parties in correspondence. But if we start here, even on the presumption that I'm wrong on the fresh claim point, the drafting of this order is important because it says file and serve, not refile and reserve. And the reason that's significant is that it is inherent in the order that the claim form was not to be treated as though it had already been filed and served at some prior point. And indeed, if Your Honour wants to look at it, it's page 81 for your note. You can see that the claim form has a June 2023 date. That's the only claim form that exists in the CFI. And indeed, Your Excellency will have noted, my learned friend pointed it out in his own skeleton, and he referred to it earlier in his submissions, that a claim form in the Court of First Instance has never been served on the defendant prior to its transfer to the SCT and then back. And so it's with that in mind that Your Excellency needs to look at what Part 18 says about amendments. So if you go to paragraph 47 of my skeleton, or to your copy of the rules, whichever is the easiest, I'm looking at RDC Rule 18.1.
Yes.
Which says a party may amend his statement of case at any time before it has been served on any other party. So the court's order issued by the consent of the parties that we've just looked at treats the claim form as though it hasn't been filed and served. In those circumstances where we don't have a CFI claim form, it is open to a party to amend without consent. It is open to a party to amend without permission of the court. And as I said earlier, the same point applies to, for example, adding or substituting parties, as has already happened in this case. So that's under Part 20. And in fact, RDC 18.3 makes that same point about changing parties. So based on the procedural position that is outlined in the court's order, i.e. you must file and serve the claim form, the claimant was perfectly at liberty to amend up until the point of service. And what that means is we're in an RDC 18.1 case, and we never get to the point of RDC 18.2 being engaged anyway. And the point that my learned friend was getting hung up on this earlier was there's no way we would have consented to an open-ended amendment. That submission's misconceived because it misses the point. If you're in the position where the claim form is treated as though it hasn't been served at all, as was my learned friend's position in paragraph 6 of the skeleton, then there would have been no need for such consent to have been sought in the first place. And the same thing goes when you're in a situation where the rules say you're filing a fresh claim. You don't need that consent to an open-ended amendment because the rules provide you can make those amendments anyway.
No, apart from what the rule provide, I mean, I think I gotta say something. I'm in line with what the defendant said. If you take the view that, well, the defendant have given you the consent to amend whatever you wants to do, because if I don't know what you want to add or amend or change to the particular claim, that's an open-end authority to you to bring whatever claim you want. And this is where the defendant said we will not be in a position to accept that, because it will still be an open-end consent for your side to bring any claim. And that's what he said. Mr. Cooper said we will not accept, and then they would. You wouldn't imagine. I mean, any party would do that. I mean, blind consent.
Yes, Your Excellency, but that's not quite the point that we're making. That might have been their position if this was an 18.2 application. So if we had already filed the claim form and particulars of claim, and then we wanted to amend our case, the only gateway for us to do so at that point in time is RDC 18.2. And so we either have to get consent or we have to get permission of the court. The point is that we're never in that territory, because the effect of both Part 53 and also the court's order is that the claim form and particulars of claim have to be treated as though they have never been filed and served.
I agree. I understand your primary case, Mr. Rory. I know your primary case, you don't need a consent. You don't need even to apply for a court to change your bleeding, either claim form or particular claim. But I'm just dealing with this, your secondary point, whether they were at least they were a consent. And from the wording of the letter and the consent order you've been referring to. Is it, am I right? You saying
yes, so
at least somehow the defendant has consented that we should, by not saying refile, they consent that we file the claim form or the particular we wish. Is that what you're saying here? Is that right?
Yeah. So just to be clear, we are not saying that they consented to the terms of an amendment in the way that you would deal with it under Rule 18.2. What was consented to and agreed upon was the scope of the directions order. And the point is that the effect, both by operation of the rules under Part 53, but also in the scope of that order means that the claim form needs to be treated as though it has never been filed ever in the CFI. And where you have a scenario where the claim form has not yet been filed and served in the CFI, when you come to questions of amendment and whether or not you needed to surpass, the point of getting the court's permission or consent, we never get to that question, because what applies is Rule 18.1, and Rule 18.1 says you can amend without permission up until the point in time it's filed and served. So that's the point, is because it's never been filed and served, because we've restarted as a fresh claim, the effect of that is this issue of consent is it's a red herring. The question for the court is, what do the rules say happen when you transfer from the CFI? What does the order say the state of procedural affairs was? And if the answer to either of those questions is that the court's order was requiring the CFI claim form to be filed for the first time, the application of Rule 18.2 simply doesn't arise.
Oh, I see. Yes.
So I just don't want to make it clear, we're not saying this is consent to a particular form of amendments.
Yes, I thought you said it. This is a wonderful secondary point, that even if the court not with you, if a fresh mean must be interpreted strictly, literally. I mean, a fresh as a new claim,
Yeah.
dispatch from what happened at the city level, and then that would trigger 18.1 only, because it's before service a fresh claim and you didn't need a consent or to apply for court. But I thought you did when you take on the point about the wording of the consent order and the letter of 6th of June, 9th of June. I thought you would be dealing with this, or try to grab the court attention. They might be sort of defend. But yeah, but now your position is that's not your case. It's not your secondary point even.
Yes, I mean, really, the first and the second point are actually interlinked, because it's about what are the rights and entitlements of a claimant before they've filed and served their case. And if you have a claimant who has just, let's say, started in the CFI for the first time and hasn't filed or served yet, they can make amendments without consent and without permission, as happened in this case, changing parties, changing the scope of the claim. And then it's at the point in time you file and serve that it becomes locked in that set of proceedings. That is completely consistent with how you deal with a case that has been in the SDT and is then transferred to the CFI, which is because you're starting it as a fresh claim again, the steps that still need to be taken under the court's procedure are the filing and service of the Part 7 claim form. And so if you're transferred as an SCT claimant, you're in the same position as someone who started in the CFI in the first place. You're at liberty to amend up until you serve. And so what's happened in this case is that the amendments, when they were served, were amendments introduced on that analysis under 18.1, not 18.2. That's the point, really. And again, if one just steps back and looks at the procedural effect of this, whether you approach it through Part 53 or whether you approach it through Rule 18.1, you have a situation where the court and the defendant is faced with a claim form and particulars of claim in the same way that they would always face it. There's no prejudice to a defendant in this scenario, because they've been given 28 days to file their defence in exactly the same way as if these were fresh proceedings in the CFI. So there's no material prejudice. And looking back to the directions that were agreed, if we were to take the view, if your Excellency was to take the view that the claim form and particulars of claim need to be treated as though never served in the CFI, the route to amendment is 18.1, it's not 18.2. The third point, which is really the fallback to all of that, is why we say the strikeout claim would fail anyway. So even if one was to take the view that the claimant's approach to fresh claim was wrong, and that therefore led to a non-compliance, and if the claimant was wrong about its approach under Rule 18.1, meaning that there was again some form of non-compliance, we're still nowhere near the threshold for strikeout. And on that, if I can take Your Excellency briefly to a couple of authorities. The first is page 201 of the bundle.
Yeah, it's downloading.
Which should hopefully eventually show up is an extract from the White Book commentary at paragraph 3.4.1.
Yes, have it. Yes.
And I think it's in the middle of the page. I'm still waiting for mine to load. But if you see the bit starting with grounds A and B, the paragraph, it says grounds A and B cover statements of case which are unreasonably vague, incoherent, vexatious, scurrilous, or obviously ill-founded, and other cases which do not amount to a legally recognisable claim or defence. And then the next paragraph distinguishes ground C. So ground C covers cases where the abuse lies not in the statement of case itself, but in the way the claim or defence has been conducted. The strikeout to be made even when there was nothing in the rule, practice, direction, or court order breach which specified that this might happen as a consequence. In many circumstances, such a strikeout would seem unduly harsh unless the party concerned was warned, possibly in writing by another party, of the risk of their statement of case being struck out if they did not comply with the rule. So a couple of points there, Your Excellency. The first is that an abusive process means that the substantive case that is being pleaded is an abusive process. So, for example, if you have the substance of a claim that attempts to circumvent some other judgment or order of the court, or when you've got a substantive case which is being pursued for an improper or ancillary purpose, that's what abuse means. It's not the same thing as procedural non-compliance. The only limb of this test, strikeout, which is concerned with how a case is being conducted, as opposed to the substance of the case, is limb C. So that's the failure to comply with a practice, direction, or court order. So what my learned friend says about abusive process in his skeleton is probably of limited relevance in this context. What we're actually dealing with in this case is an argument of non-compliance. And what the White Book then tells us is where there's nothing in the rule which specifies strikeout as a consequence for breach, it would be unduly harsh step to take unless the party is warned. The second point I take Your Excellency to is if you scroll forward to page 204, we have another extract of the White Book at 3.4.3. The previous page starts with the words however, but it says, this is about abuse. There has to be an abuse, and striking out has to be supportive of the overriding objective. If it does not follow from this, that in all cases that abuse, the correct response should be to strike out the claim. In the strikeout application, the proportionality of the sanction is very much an issue, and refers to a case in which the Court of Appeal drew attention to several alternatives to strike out. And the final sentence says, striking out of a valid claim should be the last option. If the abuse can be addressed by a less draconian course, it should be. We find that replicated by the DIFC. It's in the case of GFH and Hague, which is in the Claimants Authorities bundle. So I'm just looking for the reference for you. Apologies, bear with me. My Lordship, what I'll do is dig you out a page reference for that because I can't find it in my note at the moment. But this is the GFH v Hague case. It's not the usual one that's cited, which is a Justice Giles decision. It's one from Justice Cook 2 years after that. And it's in relation to an application to strike out for abusive process. And it's paragraph 56 of that judgment. And what it says is, what the White Book says, it said that there are categories of abuse process for many and not closed, and that the main categories which have been recognised are then described in the following paragraphs of the White Book. It is said that the court is required to strike out a prima facie valid claim where there is an abusive process, but there has to be an abuse, and the striking out has to be supportive of the overriding objective. In all cases of abuse, the correct response has to be supportive of the overriding objective of doing justice between the parties. It therefore does not follow that, in all cases of abuse, the correct response is to strike out. That should be the last option, and if the abuse can be addressed by a less draconian court, it should be. So even if we are dealing with something that reaches the threshold of abuse, one still has to bear in mind the interests of justice, proportionality, the overriding objective, and the fact that striking out is a last resort. And if there's a way for the court to case manage its way through, the court should take it. That's what the authorities say. The final point to highlight there is the position is broadly the same when it comes to non-compliance, and that's even taking into account the increasingly restrictive approach of English courts. And on that, I refer Your Excellency to the Candy and Hollyoak case, which you'll find at page 233.
Open
And
it for me, yes.
And it's paragraph 11, where it says, in this case, the initial defendants have, as they admit, been guilty of serious and significant breaches of their duties of disclosure. The overriding objective requires that there should be sanctions for such breaches, as the initial defendants also concede, but I'm not persuaded that the appropriate sanction is to strike out the defences or to grant Mr. Candy judgment on his claims without trial. These defendants' conduct of their disclosure is unsatisfactory and certainly raises serious questions about their conduct and about the merits of their pleaded case. It is not established that there was a good reason for the failure, but nor is it proved that there was a bad reason. I do not consider that in all the circumstances, it would be just and proportionate response to the defendant's default to preclude them from defending the claim. So a few points worth highlighting there. We're looking at a case where the defendants were guilty of serious and significant breaches of the duty of disclosure. So the context is breaches of the utmost serious in civil litigation. There's very serious allegations and very serious findings. And even then, the court held that strikeout was not the appropriate sanction, as even for a breach of that magnitude, it would not be just and proportionate or in the interests of justice to preclude them from defending the claim. And that's even where the judge raised questions about the underlying merits, which aren't engaged there. So, Your Excellency, it goes without saying that we are plainly, as the defendant is no doubt well aware, a far cry away from that sort of non-compliance here. And if you are of the view, for whatever reason, that there's non-compliance, you have to ask, is it serious and significant? And in light of the magnitude, is strikeout really proportionate and just? And if I can then take Your Excellency briefly back to the White Book, page 31. Bear with me, it's page. I'm just waiting for my system to load to get you the correct page number. Page 327. where I hope Your Honour should be able to find in White Book of 3.4.18. I'm still waiting for mine to load. My apologies, Your Excellency. It's page.
Yeah, 327. Right?
It's page 27 of the internal numbering. I think it's 223 of the overall page numbering.
Say the reference again.
223 of the overall page numbering. It's page 27 of the internal numbering in this section. And it's the beginning of the White Book at 3.4.18. Sorry, you're on mute, Your Excellency.
I apologize for the delay. This is something we deal with soon. Okay. Yes, we have the abstract from the rules.
Yes, and
power to strike out.
And the bit I'm looking at is the paragraph 3.4.18.
Right. Yes.
On page 223.
Yes, I'm in.
And this is in reference to a case called Walsham Chalet Park. It's the second paragraph on this page. It says the Court of Appeal held that in exercising its discretion under Rule 3.42c, the court is entitled to have regard to Mitchell-Denton principles, which apply to applications for relief from sanctions. However, in that case, the Court of Appeal stressed that the ultimate question for the court in deciding whether to impose the sanction of strikeout is materially different from that in deciding whether to grant relief from sanction that has already been imposed. In a strikeout application under Rule 3.4, the proportionality of the sanction itself is an issue, whereas an application under 3.9 for relief from sanction, the court has to proceed on the basis that the sanction was properly imposed. For reasons I'll come on to, here we're dealing with strikeout because there is no provision in the rules specifying a consequence for an irregular way of making an application for amendment. And bringing all those points together, the primary position, of course, remains there has been no non-compliance at all, either on the fresh claim analysis or on the analysis I've taken Your Excellency through on the scope of the order itself, and the fact that because a claim form had not been filed, Rule 18.1 applies. But even if you were against me on that point, and there is non-compliance, that non-compliance has only arisen from one or more of an understandable mistake about what RDC 53.41 means when it says you have to file a fresh claim, or it's the fact that there appears to have been some disconnect or some failure of meeting of the minds between the claimant and the defendant when their solicitors were talking about amendments in their attempts to agree to directions and what filing an amended claim form meant in that context. On any analysis, that sort of non-compliance, if that's what it is minor, it's trivial, it's inadvertent, it is in no way serious, not least because the claimant has already and promptly taken protective steps to try and cure it through the amended application. So given those provisions of law that we've just looked at, given the extreme cases that we've looked at that didn't reach the threshold for strikeout, including non-compliance with disclosure obligations, this is plainly not a case where that sort of sanction should fall within the court's contemplation, not even close to it. There are other avenues other than striking out the case, which are open to the court to take based on its inherent powers, which I'll come to, and based on established principles about what the court should do in these scenarios. And above all, having looked at the substance of the claim, having looked at the legal absurdity that would arise if this alternative plea was struck out and what it would mean for, amongst other things, the defendant's in perpetuity right to remain in possession of these premises without paying rent. It would obviously be wholly disproportionate and unjust to strike out that component of the claimant's claim, which is a valid alternative plea, which the defendant hasn't even tried to offer a substantive response, and which would give rise to substantial entitlements, namely substantial sums of money, a right to regain possession of the premises, and so on. So what we're already at the point of looking at is 3 different layers, we say, on which the strikeout application fails. And what the defendant has to do is satisfy you that it has the right argument in respect of every single one of those in order for its application to succeed. And even if it does, we still then have to deal with the position on the amendment application, which, as the claimant has said, is something was made out of an abundance of caution. And I've already addressed Your Excellency on RDC 18.1. But to come on to RDC 18.2, if that is in fact the gateway that's required, I set out the provision at paragraph 48 of my skeleton. It will be well known to you. It says, if a statement of case has been served, the party may only amend it with the written consent of the other parties or with the permission of the court. So as I've already said, we're only in this territory if you take the view that the claim form and particulars of claim should have been deemed to have been filed for the first time before June 2023. Your Excellency will also see reference in paragraph 49 of my skeleton to how the court envisages parties on the receiving ends of such an application should treat them. So it's RDC 18.12, which says questions of amendment and consequential amendment should, wherever possible, be dealt with by consent. The party should consent to the proposed amendments unless he has substantial grounds for objecting to it. In other words, it's expressed in the rules of the court that parties are discouraged from these sorts of contested hearing where you don't have substantial grounds for objecting to the substance of the amendment. There are, of course, examples where a court may well seek to dismiss an application. One example is RDC 18.15, which I've set out in paragraph 50 of my skeleton, which is where you have late amendments. So a party turning up on the eve of trial, trying to plead a new substantive case, when the parties have already gone through the motions of preparing witness statements and evidence and so on. But clearly we're not in that territory here. This can't be seen as a late amendment. It's an amendment, if that's how you can characterize it, that's being made right at the outset of proceedings. There isn't even a defense yet. The defendant can't plausibly come before the court asserting that it will be materially prejudiced in the presentation of its case by an amendment made before it's even put pen to paper. So the question on the amendment application is, well, what are these substantial grounds? Largely, we've already looked at them in the context of what I've had to say about the strikeout application. At its very highest, what we're dealing with here is a minor, trivial, not serious, however you want to put it, non-compliance arising from what is a perfectly reasonable interpretation of Part 53 and what is a perfectly reasonable interpretation of what the parties had thought each other were saying in the correspondence leading to the issuance of the draft order, even if in the event it turns out they were talking past each other. Respectfully, Your Excellency, it is difficult to think of a case in which RDC 18.12 could be more appropriate. This is an obvious case of the defendant having provided its consent to an amendment, as one could hope to find. And indeed, Your Excellency has already dealt with cases like this before. You'll have seen my reference to the Abdul Salam and Expresso case. But if I can just take you to what you said in that judgment, it's fairly absent of what we're dealing with here.
Yeah,
If you go
but
to page,
why you wish to go that far? Because you have not asked your opponent for any amendment. You have not put any proposal before them at all. I don't know why we're dealing with 18.12 or Salam case at all.
well, because it was raised in correspondence, Your Excellency, I'll take you there a little while. After the amendment issue was flagged.
No, I'm saying it's not in your submission anyway.
So I'm not sure I follow the question, Your Excellency. Could you repeat it?
I said, on what basis we're discussing 18.12 or the consent issues now? Because you said it's not part of your bleeding.
No. So the reason I'm dealing with 18.12 is because the amendment application is being made not for the consent of the other side. It's being made for the permission of the court. And the reason I'm raising 18.12 is that after the defendant said, you've made an amendment, you shouldn't have made an amendment, what the claimant solicitors did was write to the defendant and say, we don't think that interpretation is right, but if you're of the view that an amendment needs to be made, we're inviting you now to consent to it, so that we don't have to have this contested application to try and avoid the cost of a contested application. They said no, so we've made an application to the court. So 18.2 is engaged.
I thought this article is just for the court to supervise the conduct of the parties who've been invited to consent into an order and see whether they've been rational or not.
Yeah, so the invitation.
This position. You did
Sorry.
not send an invitation to them.
No, we did after. That's the point I'm making. So the claim form particulars of claim is served.
After the strikeout, you mean?
Yes, after the strikeout. Yeah. That's what I mean. So when I'm referring to 18.12, what I'm addressing is a scenario where after the strikeout application is made, the claimant has approached the defendant to say, hang on a minute, there's a way to carve through this, because if you think there needs to be an amendment application, we'll make one, but provide your consent to it. So they're invited to consent at that juncture, but didn't, which is the context for why we're now in a contested application, rather than this having been case managed amicably by the parties without the involvement of the court. That's the point, really.
And is that part of your evidence? Do we have it? Can you take me to?
What I'm taking your excellency to is your own judgment in Abdul Salam and Expresso.
No. I mean your correspondence with the defendant.
Yes, I see. Bear with me. It's if you go to page 151. I take your excellency is still waiting for the page reference to come up.
I just come in, yeah. Speak of it, yeah.
Yeah, so it's 14th of July letter. This is in response, this is after the strikeout application has been filed. And the substantive paragraphs start on page 151. We're surprised to receive the application, given you've had the particulars of claim since the 16th of June. We haven't received a single communication from you objecting to the contents until now, or any reason why you've waited until the eve of your defence being filed this application. If we continue down this page, we set out our stall. For the avoidance of doubt, we don't agree that we're required to seek the court's permission to file the claim form in its current form, nor can you contend that an amendment is required. Then if we go over the page, at the bottom of the page, and this sets out all of the reasons why. A lot of them I've articulated already, so I won't go through them. But at the bottom of the page says, in any event, even if the court's permission were required, there's no doubt the permission would be granted by the court, particularly where we're at the beginning of the CFI proceedings, and you still haven't pleaded a defence. We're confident that there's no basis for the application for permission to amend to be resisted, nor does your application even proceed on the basis that such grounds would be open to the defendant. So if you're going to maintain your stance that an amendment is requirement, you're likely to fall foul of RDC 18.12, which says if you don't have substantial grounds for objecting, then you should consent. And so in the premises, three options are then set out to try and, as I say, amicably find a solution through this without having to come before Your Excellency today. One, you withdraw the application immediately. Two, if you maintain the permission is required, then provide us your consent because you don't have any substantial grounds to resist the amendment. And three, we'll give you permission to file your defence. And it says that in the event that the defendant refuses to accede to these steps and persists in its application, the claimant will proceed to file an application for permission without any further notice to you, and the claimant will seek to recover its costs of doing so on an indemnity basis due to the unreasonable conduct of the defendant in pursuing the application.
I see this.
So, again, this to some extent touches on what my own friend says about the supposedly inconsistent basis in which the applications are pursued. That's obviously incorrect because there is plainly a legitimate disagreement between the parties as to the effect of the rule. The point of this letter was to say to the defendant, look, even if we have this disagreement on the scope of the rule, we'll make an application to amend if that's what you think procedurally needs to be done. You don't really have any argument on the substance of the amendment. So there's no substantial grounds for you to resist it. We're right at the beginning of proceedings. You haven't even filed a defence. So consent to this course of action and avoid this contested hearing. That was the basis upon which that offer is being made. And the reason I was referring Your Lordship to, Your Excellency, sorry, to the Abdul Salam and Expresso case is because you've already been faced with similar circumstances where you have, on the one hand, a strikeout application and on the other hand, an amendment application that's intended to cure it. And if I could ask you then to go to page 302 to look at what you said in that case.
Yes.
If we start by looking at paragraph 4 at the bottom of that page.
Sorry, give me the reference again for the case.
So it's page 302. This is Abdul Salam and the Expresso Telecom Group. And this is your judgment of the 15th of March 2020. And paragraph 4 begins with the context, so similar to the context in which we're appearing for you today. If the claimant is successful in his amendment application, the defendant will be unsuccessful on the first ground of the immediate judgment application and vice versa. This concerns a case where there are certain allegations under the employment law, there are citations of the wrong provisions of law on repeated occasions, and it's about whether those amendments should be struck out. And you'll see some of that exposition as you go over the page into 303, where it says, unsurprisingly, after a particular claimant filed, the defendant made an application seeking the claimant's claims to be dismissed. The claimant followed this application with one of his own seeking permission to amend particulars of claim. Continues along with various remarks about the merits of the claimant's case generally, which in my regard are relevant to the question of amending pleadings. The defendant took the position that the court cannot exercise its suo motu powers in remedying this fatal flaw, as the court is itself rendered helpless and faced with the prospect of having to deal with laws not yet assumed force. And you continue then at paragraph 5, which refers to Justice David Williams' judgment in International Electromechanical Services, which I've referred to in my skeleton argument. What you're saying is that the defendant in making its application is incorrect. And the cited extract says this court has jurisdiction to amend defects or errors in the pleadings on its own initiative, if such is necessary for determining the real controversy between the parties. Then continues Article 32F of the DFC court law provides that the DFC court has power to make orders and give directions as to the conduct of any proceedings before the DIFC court that it considers appropriate, including orders made in the interest of justice. And then we also have Article 44 of the court law in relation to technical defects, which is no proceedings in the DIFC court are invalidated by a technical defect or an irregularity unless the DIFC court orders otherwise. The DIFC court may, on conditions the DIFC court considers appropriate, make an order declaring that the proceeding is not invalid by reason of a defect or irregularity. And then at paragraph 6, you say, in my view, an incorrect reference to law does not invalidate proceedings and is no reason to strike out. Moreover, in the instant matter, the claimant has not persisted in his error and instead seeks to rectify it. This stands in his favour. The real controversy between the parties, as Justice Williams put it, will not be determined by references in pleadings, but rather primarily events which occurred between the parties and their legal relationship in the law, as they in fact were when these events occurred. To set aside Mr. Abdul Salam's claim on the basis of his error would be to take a severely technical approach in dealing with the case and would not, in my view, be in the interests of justice. You then refer to the provision I've cited at RDC 18.12 about amendment being consented to unless there are substantial grounds. And what you say is the defendant has failed to demonstrate substantial grounds for objecting to the claimant's application to amend his particulars of claim. Without such grounds, Expresso should have consented to Mr. Abdul Salam's application, but it did not. And importantly, I do not think that the defendant has demonstrated that the claimant has no real prospect of succeeding on his claim in respect of the first ground. As such, I am unable to come to any conclusion other than the claimant's application to amend his particulars of claim should be granted and the defendant's application for immediate judgment should be denied. Breaking that down, Your Excellency, very briefly, this court has the power, under its own initiative, to amend any perceived defects or irregularities under Articles 32 and 44 of the court law. That's the International Electromechanical case. Those sorts of irregularities do not invalidate proceedings. The court will, in the exercise of its discretion, cure them where it's in the interest of justice to do so. It would not be in the interest of justice to strike out a case, as you put it, for severely technical reasons, but instead the court will try and address the real controversy between the parties. And you also said it stands to a party's favour when the court is deciding whether to exercise that discretion if it has taken steps to try and rectify the perceived non-compliance, both in that case and in this one, by the application to amend. And unless, in truth, the defendant has a substantial ground to object, the rules say it should consent, and that is particularly so when you're finding an Abdul Salam, where it's unable to show that the claim has no real prospect of success, a point that the defendant in this case doesn't even advance. So we say it's pretty clear cut. As I've already said, the amendments preceded service. Permission wasn't required. We have all of the primary arguments we make on that. But even if it's necessary to invoke the court's discretion under RDC 18.2, we say the amendment is clearly permissible. It's an application made at the earliest possible stage of proceedings. There is no argument from the defendant concerning the prospect, and I've already taken you through what the underlying merits of what's been pleaded are. If it is necessary for the application to be made, it's only because of the claimant's quite reasonable misinterpretation of changes to RDC Part 53 in relation to a fresh claim and to its understanding of what the parties had actually been agreeing to in the court's order. And the court has the power to cure those perceived defects or irregularities if they exist. So at best, the defendant is in the position here of seeking to ask the court to take the extraordinary step of striking out a meritorious alternative plea, which it has no answer to, based on the most technical of non-compliances, which the claimant has in any event taken steps to rectify. So even if we're in the position of needing to go down this route, the court's discretion, the interests of justice, proportionality, all of the factors that Your Excellency need to take into account weigh overwhelmingly in favour of allowing the application. And we say that's the only reasonable outcome. We say, moreover, that the defendant should have known better that that is the only reasonable outcome in this case and consented to the amendment in the first place. Just touching, before I may round off, on a couple of points my learned friend made in his submissions. One is that it suggested that we need to import the English standard of needing relief from sanction in this case. That's wrong on a number of levels. I've already taken Your Excellency to the provision in the White Book, which tells us that although the considerations are similar, where we're dealing with an application for strikeout, the starting points are different than they are on an application for relief from sanction. The first main point is that this isn't a case where the court has even implicitly imposed a sanction on the claimant. So this isn't a Denton case at all. To give a counterexample of that, if you miss a deadline for bringing a jurisdiction challenge under Part 12, the rules specify that the outcome of that, unless you get relief from sanction, is you're not allowed to bring the challenge. Similar provisions exist, for example, in cases concerning application for permission to appeal. Amendment doesn't work that way. There's no time limit for bringing an amendment application, in that it would be entirely open to a party if it wanted to bring an amendment application to do so on the day before trial. Might not be very successful, but you don't have to bring it by a particular date. And the rules certainly don't say if you don't bring it by a particular date, that you can't bring it at all. And to go back to the example I gave earlier, if we take the defendant's case at its highest, it's bound to accept that the statement of primary relief sought in the particulars of claims stands as a validly pleaded claim. So that's everything up to paragraph 18 of the pleadings we looked at earlier. The position on application.
Why one cannot say the time limit for bringing an amendment? So it's the time where your opponent is act open or apply to deal with it in a certain way. Then it's a question put before the case to deal with a wrongful submission. Can that be considered a time limit?
No, it can't, because if I wanted to, I could bring an application to amend, when we've already provided closing submissions at trial, that the rules would leave it open to me to do that. My application might be a bad one, but I can do it. What the rules say when it comes to sanctions for amendments and when they're made is that there are cost consequences. So, of course, the usual order would be that if you make an amendment at a particular time and it's allowed, any of the costs of an occasion by the amendment should be borne by that party. So that is the sort of sanction you have for making an amendment at a particular point in time. But clearly, in the example I give, let's say.
There is an, tell you what, if you bring a claim form within the DFC rules, you have to serve it within a certain time anyway. And that is automatically a time limit.
That's a time limit for serving.
And if it's beyond jurisdiction, then you will have 6 months.
Yes, but that's a time limit for serving particulars of claim. That's not a time limit for making an application to amend particulars of claim, because by its very nature, you only ever make that amendment once you've already filed and served. So for 18.2,
but you're saying you are in the position in a fresh case where you have not served.
Well, that's not what the defendant says.
What I'm saying, your limitation is your time to serve, isn't it?
No, that's not what the defendant says, because the defendant is only taking issue with paragraph 19 onwards. So it accepts that.
No. You said you can. There is no limitation when it's come to the amendment of a claim form or part for a claim. But I said,
yes,
even if you have not served, there is a procedure which dictates a limitation in you. First of all, whether the rules that give you certain time to serve, or when your opponents act upon your behavior and then try to take advantage of it, so whether to strike out, whether to stop you from serving or do anything about your claim. That I think in my assessment, it might be called a limitation for you. You should have acted as soon as.
But that I suppose the point is, if you go to the rules, there's nowhere in the rules that says you have to apply to amend your particulars of claim by X date, or no later than the filing of witness evidence, or any time. What it says is you can apply to the court under 18.2 after you've already filed and served, and that in the exercise of its discretion, one of the things the court will take into account is whether they're late amendments. That's 18.15. But by its very nature, the application to amend under 18.2 is only ever going to be made after the claim has been pleaded already. So there's no conceivable argument in this case where I think the application has been made a few days after the deadline for filing particulars of claim. There's no coherent argument there which says this is a late amendment. It's still right at the beginning of proceedings, and the defendant still hasn't drafted a defence. And so the central point really that brings this outside of the relief from sanction regime is that the rules don't specify any sanction at all. You can bring the application when you want. It's purely a question for the court's discretion as to whether it considers it's late or not. And clearly that's not engaged here because, as I say, we're dealing with an amendment right at the beginning of proceedings. Let me put this in a slightly different way. Let's say...
sorry, Your Excellency, just before my learned friend does that, I am slightly concerned about time. My learned friend has had his 2 hours, and I do need an opportunity to reply.
Yes, if I may, Your Excellency, there are 2 applications. There are arguably 2 sets of rights of reply. It might just simply be better that I have my 15 minutes now to finish this, and Mr. Olive Cooper has his 15 minutes after that.
Yeah, but I have alerted you. I will be giving you similar time to the opponent at the head of this trial.
Yes, I think what I'm saying, Your Excellency, is that I have a right of reply as well. I've made an application where the applicant, and so the more straightforward way might be for me to finish my points now and then not come back to me, rather than Mr. Olive Cooper having 15 minutes, then me having another 15 minutes after him.
Well, I only had 1 hour 45 precisely so that I could have 15 minutes for my reply. Your Excellency, I mean,
yeah, no. What I allowed for 2 hours, yes, I understand. But you utilized 145. Is that up to you? But where he's supposed to utilize 2 hours, but if there is a significant point, whatever. If your point already dealt with in your skeleton argument, I would urge you to be super brief, Mr. Dorton, and then I will give you some chance to rebuttal, Mr. Cooper.
Yes, I'll deal with the point very quickly, Your Excellency. The issue here is that there's no sanction that is applied by Rule 18 we never get into the consideration of this as a relief from sanction case. Putting it slightly differently, as I was going to say, let's pretend the particulars of claim had been filed up until paragraph 18. It would have still then been open to the claimant in a month's time to put in an application to amend, and there wouldn't be any issue with that application at all. The only
well, maybe the sanction, I don't know, I remember Mr. Cooper said, well, once you have, I mean, in his primary case as well, Mr. Cooper was saying, well, you're not allowed to bring an amendment anyway, because he's taking the theory you already submitted before the SCT, and then this is subject again to the interpretation of afresh and what it means and to what extent you can bring a fresh claim that beyond the boundary of what you cause of action that brought before the SCT. But let's resume this. Put aside, I mean, then your interpretation toward afresh. Okay, he said you're not allowed to bring, I mean, from Mr. Cooper's point of view, you're not allowed to bring an amendment to the before the court. Once you haven't done so, that's a trigger the sanction automatically.
In the most respectful submission possible, that would be an absurd outcome, which would mean that an SCT claimant would be fixed with his originating claim form in a way that no other party in the CFI would, because any other party in the CFI, if that's where their claim originated, would be at liberty to make an application to amend, seeking the permission of the court at any time they chose to do so. It would be an astonishing consequence of the rules if you, as an SCT claimant, were materially disadvantaged and not able to utilise the entirety of the course of procedures once you've been transferred to the CFI. So I struggle to understand how that position could possibly arise. As I say, the point I was making is that we're not in sanctioned territory, because to be in sanctioned territory, there has to be a sanction arising in the rules. But here there isn't. And the second point really is to say that submission doesn't really go anywhere anyway. Your Excellency will be familiar with the Mad Atelier case. But if you are going to actually apply the three-stage Denton approach, it doesn't really move matters on, because we're nowhere near the threshold for justifying a refusal of relief. So question one, is the breach seriously significant? I've already addressed that. No, it's not, because it's at best minor breach of the rules, which the claimant has already taken steps to rectify as soon as there ever became an issue about it. Was there a good reason for the breach? Yes, because the claimant quite reasonably interpreted the rules one way, the defendant interpreted them another way. And finally, what does dealing with the case justly require? As I say, I've gone through those submissions. Strikeout is a last resort. This is a meritorious claim. The defendant has no defence to this claim, and the only place that the interest of justice can lie here is in allowing the amendment, if that is what's required. So the simple point is the relief from sanction analysis doesn't get you anywhere. And then if I could just give you, in the interest of time, if I could give Your Excellency just a couple of paragraph references in relation to a couple of the cases my learned friend relied upon, so that you can actually look at the broader context. The first was the JSC case, page 434. My learned friend referred to a particular extract, paragraph 51. But what you need to go look at is, first of all, paragraph 47, which refers to the underlying case law that led to the decision, which is a requirement that it be manifestly unfair for a party to litigation, that principle to apply. And then also in paragraphs 51 and 52, which makes it clear that the context of that case is dealing with the Henderson and Henderson type abusive process. And then the second is the Attorney General and Barker case at 339, where my learned friend says that all that is required to strike out for an abusive process is that you have a party who's using a process for a reason that is different to its ordinary use. And I would go back to what is said in that judgment, as I say, page 339, because what the court says is, in those circumstances, what you need to find an abusive process is a vexatious claim, the hallmarks of which are having little or no basis in law, that whatever the intention of the proceedings may be, its effect is to subject the defendant to inconvenience, harassment, expense out of all proportion to any gain, and involves an abuse of the process of the court, meaning that the use of the process is for a purpose or a way which is significantly different from the ordinary and proper use. It's only the latter part of that my learned friend cited. The broader context is obviously relevant. The final point, Your Excellency, I don't know what your intention is in terms of reserving judgment or not. This is a case where the claimant would want me to say it's been kept out of his money for a long time. That includes adjournments from the SCT. It includes being forced to contest an application today, which we say should never have been a contested application. And if you are minded to reserve judgment, I'd ask you to bear in mind what I say in my skeleton argument about cost of the proceedings.
Yeah, I think I'm willing to deal with this case in sort of expedited basis. If there's a two application in expedited basis, I would, if I see it might take me a bit longer time to for reasoning, I might issue order with reason to follow, so party could move on this case, or it's the whether either way strike out or allowing the amendment. Thank you, Mr. Absolutely. I will turn on now to Mr. Cooper.
Your Excellency, I'm very grateful. My learned friend has done a very good job at muddying waters that should be crystal clear. He says now that he's no longer arguing that we consented to the amendments under RDC 18.2. That's news to me. That's the first time that my learned friend has made that concession. I mean, obviously it's very welcome, but I do wish that he'd made that clearer at the outset. What it means is that we can focus in on just this argument that they didn't need permission or consent at all because of his interpretation of RDC 53.41. So can I ask the court to turn up that section again?
Section 53?
53.41.
Yes.
Rules.
Yes, Mr. Cooper.
Yes, so again, what my learned friend is saying is that the words to be progressed as a fresh claim under the procedures followed by the CFI have been inserted with the intention of saying that a claimant can basically just start again with a completely new claim form. The substance of it can be completely different and the parties can be completely different. Your Excellency, as I explained in my submissions, that is not what these words are intended to do. What these words are intended to do is say, in terms of the procedural steps, you go back to the beginning. So you go back to the beginning in terms of, yes, filing the claim form, but that claim form can't be materially different to the claim form that was already filed in the STC. And then particulars of claim and defence, etc., etc. We're not saying that you can pick and choose which steps from the CFI that you have to go through. My learned friend suggested we were.
So, Mr. Cooper, when you said it's a procedures, you mean it's versus substantial claim and bleeding. That's what you mean. When you said to start afresh before CFI, you said from proceeding point of view. Does that
Yes.
mean proceeding? You mean versus substantial claiming and submission?
Exactly. So it's the procedural
Like
steps.
you mean like paying fees, using the right form, case management? That's what you mean?
Yes, I'm not sure about paying fees, because that would seem to be unfair on a claimant to have to pay the fee twice. I mean, maybe if
No, I meant to amend, maybe to amend the fees.
Yeah, I mean, what I mean is you have to follow the same procedural steps, claim form, particular claim defense, etc., etc. So because some of those steps might have been missed in the previous, in the small claims tribunal, but that doesn't mean that the claim can be radically different, or indeed different at all. And my learned friend really had no answer to the point that if that was the case, it would make the consideration that the court has to undertake when considering an application under 53.41 totally impossible. I mean, if the case can really change completely, how is the court supposed to know what the value of the claim or the subject matter of the claim or the nature of the claim is going to be when you get to the CFI? How is it going to know that the claim that ends up in the CFI is in fact more appropriate for the CFI if that claim can be changed completely from the claim that it's looking at the time? And my learned friend just had no answer to that point.
So we will invite him to answer this. But what's I mean, what's led you to believe that it's only, so the word fresh means procedures point of view, but not substantial point of view.
Well, because Your Excellency, it says as a fresh claim under the procedures followed by the CFI. I mean, the words under the procedures followed by the CFI clearly indicate that what the words fresh claim are intended to be correspond to procedural steps, not you can issue a fresh substantive.
The procedures under CFI governs the conduct of the substantial claim anyway.
Exactly. And
your guidance to deal with the substantial, with the submission, how to substantiate your case, and everything is in the rules of the CFI, isn't it?
Yeah, so under the rules of the CFI, if you want to change your claim, you have to apply to amend. So it starts as a fresh claim in the sense of you go back to the first procedural steps, but with the same claim. And Your Excellency, that's pretty clear when you read the first paragraph of 53.41 in whole, because it says that what's being considered is that the small claim be transferred to the court of first instance. The small claim, not some completely different claim that the claimant might come up with after this order is made. It has to be the small claim under consideration, which then appears in the court of first instance. Whereas my learned friend is saying that it should be read as something on the lines of the small claims judge may issue a reasoned order that an entirely new claim can be begun in the court of first instance. And the word the small claim be transferred just be completely ignored and read out of this paragraph altogether. That is wrong. And obviously so when you think about the consequences, as I say, of how would the court, I mean, Your Excellency will put himself in the position of a judge trying to use this rule. If what my learned friend says is right. I mean, how would you actually do it? I don't know the answer to this question, because you wouldn't know the nature of the claim which might appear in the CFI.
No, myself, I have to deal with it, but I understand you're trying to apply rational to the interpretation of this rule.
Yes, well, I am trying to give a rational interpretation to the rules. My learned friend's interpretation is not rational. And I mean, at points, my learned friends tried to get around this by saying, oh, well, our case is that we're actually just sort of extending our existing claim. We're not radically altering it. But that's beside the point. The question is, what is the correct construction? If Your Excellency gives a judgment that a party can change his claim in whatever way he wishes, then future parties will do exactly that. So the question is not just what is my learned friend doing, what amendments is he making, but what is the logical outcome of his position? And he's quite explicit in his skeleton argument and today that the logical outcome of his position is that the claim that turns up in the court of first instance could bear literally no relationship to the claim in the court before the small claims tribunal. different parties, different causes of actions, different remedies. I mean, in what sense in that world is this actually a transfer? In what sense is this a reallocation? It wouldn't be. So I must say, my learned friend, as I say, did a good job of trying to muddy the waters in this respect, but the position is really crystal clear. And Your Excellency, I'm conscious of time. I also want to lay to rest this notion that because the claimant is serving a new P701 claim form, that means that he's in 18.1 territory and not 18.2. Can I do this by reference to my skeleton argument? Your Excellency, do you have my skeleton argument paragraph available to you?
Yes, I do.
We're interested in paragraph 38 of my skeleton.
Yes, just right before me. Yes.
The
claimant's second argument. Yeah.
When your Excellency is forming his judgment, I just ask you to go back to this point in my skeleton. The mistake that my learned friend is making is to say that because he's filing a new piece of paper, that means he's filing a new statement of case. He's not. He's filing the same statement of case, or he should be filing the same statement of case, just on a set out in a different format. And so what that means is that you're not in 18.1 territory. If that's Your Excellency, if you could just pull up 18.1. So it says a party may amend his statement of case at any time before it's been served on a party. So the statement of case here is the claim form, the sort of concept of the claim form. And it's unarguable that my learned friends and the claimant have already served a claim form. They served the Small Claims Tribunal claim form. So just because they're putting the contents of that, just because they're putting the contents of that document in a new format, doesn't mean it's a different statement of case. It's the same statement of case. And therefore it's already been served. Your Excellency, this is absolutely key. I want to make sure that I'm expressing myself clearly. Are you with me on this point?
Yeah, you're saying even at that point, what he's amending, like even if he said he's amending, he must have amended something he have submitted earlier. And what is that submitted earlier? We don't have anything but what have been submitted before the SCT. Then he still have to be, and then the amendment must, in general view, not depart from what's been submitted earlier, or he need to follow the, let's say, the rules of change amendment statement of case. That's what you're saying, is that right?
Well, yes, I mean that is right, Your Excellency, but I think I'm making.
Yeah, I mean, let's say even if you bring a statement of case afresh before CFI, you never been to SCT, no SCT engagement at all, and you wishes to bring amendment to your statement of case, there is limits to that amendment itself. That's what you're saying.
So if the statement of case, if they've served a claim form in the Small Claims Tribunal, which in this case they have, then they have served their statement of case. And even if they then go to the court of first instance, even if they then transfer the contents of that statement of case onto a P7 claim form, that document is still the same statement of case. And so if they want to change it, if they want to fiddle with it in any way, that's an amendment. And they can, as 18.2 says, they can only amend a statement of case that's been served with the written consent of all parties or with the permission of the court.
Yeah, but I don't know. I mean, to be fair to Mr. Doherty, I mean, and he would in his term he would clarify this. He's not just saying we are in a, when he said it would be 18.1, but he said we do file a fresh claim. Filing a fresh claim, we didn't need a consent, we didn't need anything. I remember him calling that. He said,
Yes.
I'm not only in the context of amendment, whether 18.1 or 2 or 3 or 5, but he said, I am in a position of filing a completely new claim, and I'm not bound by whatever being submitted before the SCT. So we can't even like, or one might take from his mouth when he said, well, I am amending according to 18.1, but I know then Mr. Kubri said, you amending what exactly? So you try to push him to a corner where he is amending what's being submitted before the SCT. Is that what you're trying to say? But what I'm saying, I mean, to be fair to Mr. Doherty, but I guess he have said both. But at many times he have said, I'm filing completely a fresh claim. Well,
Yes.
he do said sometimes I fall under 18.1, 18.1 being amending statement of a claim. I mean, amending something mean you must have submitted something earlier. Is that right? That's what you're trying to do.
Your Excellency, yes, I actually understand the way you're putting it. I mean, if he's coming in under 18.1, he must have filed something before, in which case it's not fresh.
Yeah,
it?
but that's what I said. I mean, to be fair, I mean, I would leave it to him, but he might have come in, and I remember he said fresh claim, and what a fresh claim mean, and he said I didn't need permission, I didn't need anything.
Yeah. Well, Your Excellency,
but I do realize he have positioned himself under 18.1 sometimes. Well, which it might mean the things that you just said trigger. You are amending what exactly, Mr. Dory? I mean, and then that's up to him to answer. But
yes,
I hope this does not extend the trial for today a lot.
Your Excellency, I think you have the point. So we say
I got your point. Yeah.
Yeah, that we say that his construction of 53.41 is just obviously wrong as a matter of logic, and he definitely does not come under 18.1. Although, as Your Excellency points out, even if he did, that would be a bit problematic for his position that that it's a fresh claim. So I won't belabor that point. I won't belabor that point any further. My learned friend said that if what I say is right, then the claimant is put at a disadvantage because the defendant can express his defense for the first time, whereas the claimant would be stuck with his claim form. Well, that's not right in two ways. One, he can apply to amend his claim form. So I'm not saying you can never amend, I'm just saying you can't amend without permission. And secondly, the claimant ordinarily won't have pleaded a particulars of claim. So he'll have the opportunity to spell out his claim in more detail in the particulars of claim, provided that is just an elaboration of the claim form. So there's no procedural unfairness. Both parties will be articulating their claims in more detail for the first time in the court of first instance in the ordinary way. My learned friend at one point asked why we didn't object to the amendments made on the 14th of December 2022. Well, that's because at that point we hadn't been served with a claim form before, so they could amend without permission. We were only served with a claim form for the first time on the 3rd of February 2023. After the 3rd of February 2023, if they wanted to amend, then they had to seek permission. Your Excellency, I'm conscious I'm maybe testing your patience, but just a few more points. My learned friend made some submissions on abusive process. He said that where there are less draconian options, you should take those alternative options instead of striking out. But he didn't actually go on to say what those alternative options might be. As I said in my submissions, it is difficult to conceive of what an alternative sanction could be for amendments that have been improperly made. And my learned friend didn't offer any alternatives. So all of his citations about the importance of looking for a less draconian alternative, whilst right in principle, have no application on the facts of this case.
But I think he said nothing trigger a sanction because there is no limitation to my amendment.
Well, he did say that, and I'm going to come on to that point. That's wrong. Your Excellency, I took you to a case which showed that it's not just situations where there's an express sanction, where relief of sanctions is required. it's also situations where the court imposes the relief from sanctions test for good policy reasons. And I just, Your Excellency, I just ask you to go back to the, when you're preparing your judgment, I'd ask you to just go back to the Wolf Rock judgment, which I cited, and read it again, which makes very clear that it's not just cases where there's an express sanction.
The implied sanction?
Exactly. So there are situations where there's an implied sanction, and this is one of those situations. Now, my learned friend said that can't be right because there's no time limit for amendments. But yes, there is. You have to have passed the test for 18.2 before you make the amendments. So the time limit is before you make the amendments, whenever that happens to be. What you can't do is make the amendments and then say, whoops, I needed permission. Let me come back and get permission without meeting the relief from sanctions test. It's just like if you say that you've got a deadline coming up. If you apply for an extension of time before the deadline, you just have to meet the overriding objective test. But if you miss the deadline and then you apply for retrospective permission for a retrospective extension of time, then the court will impose the relief from sanctions test. It's exactly the same here. If you apply before you amend, then you just have to meet the real prospect of success test. If you amend and then try to get retrospective permission, that's when you need to meet the relief from sanctions test, because you've already breached the rule. You're already in a position where you've amended in circumstances where you're not allowed to. The appropriate sanction for that, as I've already said, is strike out, because there's no other option. And then if you want to reintroduce those amendments, then you need the relief from that sanction. Hence the relief from sanction.
You're saying it's defected amendment, so it's a trigger the sanction.
Exactly. If you make defective amendments, you need relief from sanctions. If you apply to amend before you've made the amendments, then you don't, but they didn't do that. And this ties into my learned friend's points about us not having substantial grounds to object. The point is that as soon as he missed the deadline, that gave us substantial grounds to object, because he's missed the deadline. Our basis for objecting is precisely that. And then the appropriate test is not the real prospects of success test, it's the relief from sanctions test. I've already explained why I don't meet that test. So we do have substantial grounds for objecting. And Your Excellency, just finally, my learned friend took you to the decision of Abdel Salam, pardon me. If I can, actually, Your Excellency, I will just take you back to it if I may. It's in.
It's open before me anyway.
But it's already before you. Excellent. So if you go to this page 105 of the internal numbering 105, let me just give you the
303 in my overall.
Okay, 303. Excellent. I'm grateful.
Or 4 if you wish.
So 303, you said, Your Excellency. Oh yes, okay, I see. Pardon me. So the position in this case, as you saw, was that the claimant had issued a claim, and the only problem with that claim, or at least the only problem which the court was going to deal with, was that he'd issued under the 2018 employment law when that law hadn't come into force yet.
Yeah, wrong reference.
Yeah, the wrong reference, exactly. And so it's completely unsurprising that in those circumstances, Your Excellency said, this is an incredibly minor defect, that there's no reason to strike out the claim on that basis. They're going to have permission to amend. That is nothing like the present case. there, the only question was, if you put the correct references in, would the claim have a real prospect of success? Whereas here, the question isn't, do they have a real prospect of success?
Well, Mr. Cooper, yes and no, because sometimes wrong reference is completely wrong cause of action. Sometimes. Many times.
You're quite right, actually. So sometimes it might make a difference. On the facts of that particular case, you held that it wasn't a sufficiently serious.
Well, I can tell you, like, if you address a statutory penalty in employment law and you give just wrong reference to the, let's say, the year, you know,
Yeah.
because the statutory penalty kept changing over the years. It's 2005 different approach, 2015 different approach, another approach 2019. You know,
making it easy
yeah.
to adjust. Yes, well, you're absolutely right. But I mean, on that particular case, this was not a serious issue. And so if you just put in the right references, then the claim would obviously have a real prospect of success. But here, the question isn't, does the claim have a real prospect of success? That's not the point. Here, we're dealing with a breach of a fundamental rule of procedure. And the question is, does the claimant meet the test for relief from sanctions? And if the claimant doesn't meet the test for relief from sanctions, then they can't amend, regardless of whether they have a real prospect of success. And if it may be that my learned friend says, well, that's going to cause the claimant prejudice, maybe so, but that's the consequence of breaching the rules. And if that breach was as a result of a mistake on the part of his lawyers, then he has other remedies. So that's the situation we're in, Your Excellency. Abdel Salam is just not a relevant authority when it comes to this particular case. And my learned friend really, I think, struggled when he came to trying to explain why he would meet the test for relief from sanctions. It's plainly a serious breach. There was absolutely no good reason, regardless of whether this was an inadvertent breach or not. And as I say, it's a very bad precedent if a party in the claimant's position is entitled to amend, regardless of their previous breach of the rules. So for all those reasons, Your Excellency, we would invite you to grant the strikeout application and to dismiss the amendment application.
Thank you very much, Mr. Cooper.
Thank you.
Yes, in a quick manner, Ms. Curry.
Yes, I think it's probably just to address the brief points Your Excellency was discussing at the end, and this is in relation to what a party can do under RDT 18.1 before service. The point that my learned friend was saying, well, you know, for RDT 18.1 to apply, you must have filed something. Slightly misses the point, because what RDT 18.1 says is that prior to service, you may amend without consent and so on. So the question of something having been filed doesn't actually get you anywhere for exactly the same reasons I took Your Excellency to earlier. When you look at the multiple iterations of the claim form, including those with different parties, including those with different particulars of claim and so on, all of which were amended prior to service, there's no issue with doing that. A party can have an issued claim form and amend it at any point prior to which it's served. That has the same legal effect, as I said earlier, as when a case is transferred back from the SCT.
Sorry, I didn't get you. I really didn't understand this.
Well, so under 18.1, if you've issued a claim form, there are two provisions that apply. One is if you've served.
Mr. Cooper says, if you would like to amend even under 18.1, you must have you're amending something. And what is that something? It happened to be something you already submitted before the SCT and served to the other party. He said this argument isn't helpful for you at all.
Yes, and it somewhat misses the point, because what Article 18.1 is dealing with is the question of what you can do prior to service on another party. So the example from this case is if you have issued but not served a claim form, you can amend it at any point prior to service.
Or you're applying fresh. You are amending or you are applying afresh.
whichever way you look at it, under RDC you're put into the same boat, because once you go through the RDC 53 route, it puts you in the CFI as if you're just starting afresh. So you have your claim form, it's issued, and you can amend it up until the point of service.
You didn't need to position yourself under than 18.1. You just go to, I think, RDC 4.
Yes, it's just really the point arises from two different provisions. One is what does the rule say, and then two is what does the court's order say. And because the court's order that was issued for direction said file and serve, not e-file and reserve, it was treating the CFI claim form as having never been served in the first place. And that's
Yeah, and the order did not say amend. The order did not say amend. Maybe if it said file, then you either file afresh only.
Yeah, exactly.
See, it's a bit controversial. It's what it trigger 18.1 is from Mr. Cooper is which is you build most of your, by the way, argument based on 18.1. He said it's missing a point. I mean, what do you, because part 18 is amendment of statement. 13H of 18.1 is amending before serving. He said you're not in all of these categories. It won't help you. And you did not argue that. I mean, what I've heard from you, I mean, you said this is a new filing, but it is not your maybe primary submission. Did you skeleton argument not based in the theory? This is a completely fresh new claim, like you never gone to a city before.
Yes, that is correct. That's the primary point. I think that the point I was making
is the primary point must be put in context and a clear one.
And the only point I was making was effectively when you compare the situation of someone who's been transferred and is filing a fresh claim, it's exactly the same as a position would be if you were a claimant for the first time in the CFI, where you had issued a claim form but not yet served it. And the point of comparing this, exactly, that's the point, is that under both routes,
let me ask you. Let me ask you this: if you have submitted at the CFI level, okay, CFI level, you have submitted employment claim. You haven't served it, but you lodged the claim form. You paid fees and everything. Can you amend your employment claim form to be basically commercial claim form, and then part of a claim based on a commercial one?
Well, it's not
transaction. Is it? I mean, we need to be very specific in here. Like, to what extent you have freedom of amending and to depart away from what you have submitted. I said, if we take a fresh filing, that's a different thing. If you want to rely in, and you need to amend according to whatever you want to do with it, and then you might be bound by certain, I would say, theories or doctrine related to the amendment. Because the faction, well, you know what I mean?
So the answer to that is that the court still has oversight of a scenario like that. So let me just work through a couple of different examples. To take the one Your Excellency has raised, if I file a claim as an employee, if I issue it, if I haven't filed and served it on the other side, what I can do before I file and serve it is say, let's say I'm employed by a DIFC entity, but I also want to add an onshore entity. I can make those amendments to the claim form before I serve it without seeking consent or permission. Similarly, if I had an employment claim, which I pleaded as, let's say, dismissal without cause under the employment law, but I reflected on that and thought, well, you know what, just to be safe, I'll also plead a claim under the contract law for something else. I could do that before I filed and served it. I wouldn't need the permission of the court, and I wouldn't need consent. If I'm an employee and I have issued a claim against one party for a breach of contract, and then I amend it, say, to include someone who's completely a different party, has nothing to do with the underlying set of proceedings, and I allege that they're engaged in a civil fraud or something like that, the effect of doing something like that would be that the rule at 18.4 RDC would bite. And what 18.4 says, if a party has amended his statement of case where permission of the court was not required, the court may disallow the amendment. So the point there is that the court still has discretional oversight if it takes the view that someone is overstepping the mark or making an amendment that's beyond what could possibly have been contemplated to have been included in the original claim. What it doesn't mean is that you need to go to the other side and seek their consent. And what it doesn't mean is that you need to make the application to the court in the first place. The court has its own inbuilt rule to deal with amendments that it thinks have gone too far.
Well, you say, Yusuf, there are limitations. Otherwise, the court will not intervene and disallow something. If it's a completely free standing right of change.
Yes, and there are provisions already that exist in the rules that would permit the court to step in if it felt that an amendment made under 18.1 was an overstep of a mark or constituted an abusive process or something like that. So the point really is the court has a mechanism for dealing with the problem that my learned friend thinks exists, but we're not in that territory here because we're not dealing with a claim that is completely different to what was contemplated in the first place. So that's really the 18.1 point. I don't think that there's any dispute that in the ordinary course, forget all of the SCT stuff. If a claim form had been issued but not filed and served, it would be open to a party to make those amendments without going through 18.2. The fundamental problem that all of this, of course, comes back to from the defendant's perspective, both on its strikeout application and on the resistance to the amendment application, is it's formed a view that an amendment would have been necessary. It says that because there was a procedural defect, what the court needs to do is strike that out. And whatever way you get into that issue, whether it's going through strikeout principles, whether it's going through the Abdel Salam case, the judgment of Your Excellency, if it's going through relief from sanctions principles, ultimately what they all boil down to and what they all ask is this a serious and significant breach? What are the reasons for it? And ultimately, what is the order that the court needs to make in the interests of justice? And that's where the defendant doesn't really come up with anything substantive at all. What is their objection? The only possible point that they can rely on their best case is a minor non-compliance with an application it says should have been issued, with agreement between the parties on that. But where we've even formed the view that this is a non-compliance, the court then has to weigh, well, what do the interests of justice demand here? Is it striking out a valid claim to which no defence has ever been mounted for premises which the defendant is occupying rent-free and has done for well over a year, and where vacant premises is vacation of the premises is being sought, on the one hand, against what exactly? What is the prejudice to the defendant? It's at the beginning of proceedings. It hasn't put pen to paper on a defence. It hasn't incurred any significant cost that wasn't of its own doing anyway in seeking to adjourn off the SDT proceedings. And what's the prejudice here? In what possible world can it be in the interests of justice to strike out a valid claim on the basis of a technical procedural disagreement? And that's why this case falls pretty squarely into what Your Excellency was dealing with in the Abdel Salam case. The court does not, as a habit, certainly not in this jurisdiction, take the approach of adopting an overly technical approach to these issues, which it's common ground the court has the ability to cure in this case. And so if the court gets to this point of the analysis, which of course you don't need to if you were with me on part 53, but if we do get there, the court can and should cure the technical defect. And there are no compelling reasons at all articulated anywhere as to why the court would strike out this claim. Speaking of what would set a bad precedent, where you've got a defendant who's dodging a legitimate claim, who's dragging its heels, and who's putting in obstructive and we say speculative applications for opportunistic reasons, the bad precedent is in rewarding that sort of conduct.
Your Excellency, just very briefly, if I may, that last submission amounts to saying that.
For the last amendment for both, please. Yeah.
That last submission amounts to saying, even if I've breached the rules, I shouldn't be punished for it. I should receive no sanction for it whatsoever. That is obviously not the position. That cannot possibly be the correct position. If you breach the rules, there must be a sanction for it. And if that sanction isn't expressed, and there's no other means of curing the breach apart from strikeout. Strikeout is the only possible sanction. It can't be the case.
Well, maybe the sanction can be cost instead of strikeout, Mr. Cooper, isn't it?
Well, I'm not sure how the court would go about quantifying what it costs to us in this circumstance. I mean,
I'm not against you, but I'm giving hypothetical. I mean, hypothetical.
But I don't know
example,
how. What costs? I mean, anything. What costs would we be awarded? I mean, anything which leaves the amendments in place means that there's no effective sanction.
But you know, it's a standard that the court will need to deal with the seriousness of the breach as well.
Well, quite. I entirely agree. And the notion that you can amend without permission and that's not serious, I think it's quite striking.
And it's in the interest of justice as well. And I understand a lot of factors can be taken into account.
Yes, Your Excellency, I'm grateful.
Well, I'm grateful to you both. I will reserve this and I'll try to deal with it as soon as, hopefully, as I said before, if it turns to me that the reasoning might take longer, I might deliver a judgment with the order with the reason to follow.
I'm very grateful, Your Excellency.
Thank you very much.
Grateful. Thank you, Your Excellency.
Have a good day here. Thank you. Bye-bye.